call this meeting to order. It's 8:34, and I would love Commissioner Callis to give us the prayer. And again, Dr. Callis, thank you for what you do. Thank you for your service and how you healthcare industry as a whole. It's the quiet giant of heroes. So thank you for that. So if you don't mind, lead us in prayer.
Thank you. Let us bow our heads. Lord Jesus, creator of all good and loving, we ask for your blessings today as we make decisions throughout the state of Texas on behalf of all Texans. Let us think with clear, transparent, and loving thoughts. Let us be fair in debate. And most importantly, let's remember we are all created under your guidance and love. Lord Jesus, please pray for everyone during this time of year that they continue to have health, protection, safety, and protect everyone from the harms of COVID and any other debilitating diseases. Lord Jesus, finally, your love, compassion, you dying on the cross for our sins allows us to be free. And Americans, we are free because of your love and your consistent prayer. In Jesus' name we pray. Amen.
Amen. Thank you, Dr. Callis. Okay, we're going to do a roll call. Tamla, will you please roll? Oh, there you go.
Yes, sir. Good morning. Chairman Rick Figueroa.
Here.
Vice Chairman Tom Butler. Dr. Ray Callis.
Here.
Commissioner Helen Collier. Commissioner Nora Castaneda.
Here.
Dr. Gary Weston.
Here.
You do have a quorum.
Mr. Chairman, can I make a motion?
Yes, sir.
I make a motion that we excuse the two commissioners that are not present. I know Commissioner Collier might be coming, but I would like to make a motion to excuse them from this meeting.
All right. Any objection? Motion carries. Thank you, Dr. Weston, for seconding it. All right. So if Commissioner Collier comes on, Tamla, just let me know if I miss her for whatever reason. I want to make sure to recognize her as she comes on board.
Yes, sir.
Let's start off with item C on agenda. Mr. Trout, are you on? Where you at? There you are.
Yes, sir. I am Chairman Figueroa. Thank you very much.
Yes, sir. You are a big fish in a big pond. And so, yeah, it took Brian Francis a little bit to get what I was saying. But anyway, we would love to recognize you on behalf of the commission. I'm going to read this to you. I want to say this is a big deal. National Border and Boiler and Pressure Vessels is a nonprofit organization, 59 members, that promotes boiler and pressure vessel safety across the world. The NBBI was established in 1919. It standardized boiler inspection in the U.S. and Canada. Rob Trout became the NBBI member in January 2013 when he was hired as a Tdlr Chief Boiler Inspector. Over the last 8 years, he's been involved in committee work in various ways supporting the NBBI and its mission. This year, Mr. Trout was elected as the chairman of the National Board of Boiler and Pressure Vessel Board of Trustees. He stated, "This is the highest honor I can receive as the powers of the NBBI are exercised. It is business affairs conducted and is property managed under the direction of the Board of Trustees. Tdlr and the Commission as a whole is proud to have our Chief Boiler Inspector, Rob Trout, serve as chair for the Board of Trustees for the National Boiler Board." So, Mr. Trout, applause.
Thank you, Mr. Chairman. I would like to say, if you have time, I owe everything to my Tdlr leadership team. I have been blessed in the fact that I have Mr. Francis to learn from as a leader, Lee Perham, Sharp Miller. All of my leadership team has just been awesome, and I really appreciate the support that they give me and actually letting me do this. I truly enjoy what I do, and now that I can do it on a next step higher up, I greatly appreciate it, sir. Thank you very much.
Well, represent us well, Mr. Trout, and there's no coincidence Mr. Francis was born in 1919 as well when this was established, so that's we'll figure about that, right? All right. Thank you, Mr. Trout. I'd also like to recognize, and this was something that when I heard about Mr. Trout, I wanted to recognize there are a few great obstacles in life, right? The Ironman competition, right? The 100-mile marathon, right? Navy SEAL training. Right up there is what we call the legislative team, right? And they are equal on those tasks. And I wanted to take a minute to recognize them. So this reads, this year's legislative session certainly provided its own challenges, holding a hybrid in-person online meetings in the middle of a pandemic, COVID testing, and a week-long shutdown due to an unprecedented winter storm. Add to that the agency's sunset review and the talk of agency transfer mixed with budget cuts, and you begin to see the session that Tdlr legislative team just successfully navigated. And I say, just bring it on. We just woke. That was just a tickle to us. Bruno, Steve, Jeff, Jeremiah, Jessica, Tony, Hammett, Karen played an integral part in our agency's success this year. All of them logged a good number of steps walking to the Capitol, many days. Not yet, Mr. Francis. Don't clap yet. Just hang on a second. He's already good. Standing in COVID testing lines just to be present, assuring the agency was available for hearings. Should legislators have any questions, Hammett and Tony logged in many late nights, preparing cost estimates, reviewing bills for their physical impact on our agencies. Karen led the executive staff team in its collection and cataloging the bills, bill analysis, and cost estimates, and employed our new Teams platform for the collection and sharing of data and for the calendaring of hearings. Karen and Jessica met weekly to go over the calendar and make hearings assignments for the staff, determine who needed to be in the room and who needed to be listening from a distance. The commission, Tdlr, the governor, the state, the people of our great state are grateful for the talented legislative team for their hard work during the 87th legislative session, which by any means is, let's just hope that's an anomaly. Let's just pray that's an anomaly. A team that secured the funding for continued development of our new licensing database system, navigating the agency's legislative intensities, and saw the sunset continuation until 2033. So thank you, Karen, Jeff, Tony, Hammett, Bruno, Jeff, Jessica, and Jeremiah. Cannot tell you what a great task that was. You guys well earned. Well done. And I you tell you the sausage sometimes wasn't pretty. It was not pretty, but it was made, and so we thank you for that. So going on to item E, which is public comments. Tamla, are we ready for public comments?
Actually, sir, if I'm not sure, we have two public commenters who have requested to be here. But I have an identified caller number 9, and I'm not sure if that is one of our public commenters. So
I'll tell you what, I'm gonna give you a couple more minutes, and then I'm gonna go to item F. If you don't mind, I need a motion for electronic signatures, and then I'm gonna go to item G for the minutes. And then we'll
Mr. Chairman, I recommend that we accept electronic signatures, and we also approve the minutes.
Is there a second?
I'll second.
All in favor, say aye.
Aye.
Any opposed? All right. Motion carries. So, Tam, you need more time?
sorry, Chairman, we cannot confirm our public commenters are connected. May we move this to a later portion of the agenda?
You bet. Just wait me. We're going to go to item H, which is the rules. Is Wendy Pello in? I can't.
I'm here. Can you hear me? This is Wendy Pello. Good
Oh, there you
morning.
are. Yes. Good morning, Wendy. How
Good
are you this
morning.
morning?
I'm doing great. Thank you.
Okay,
Good morning.
Were they going to call in or were they going to?
Go ahead and mute everybody. Wendy, go ahead.
All right. Thank you. Good morning, Chairman and Commissioners. I'm Wendy Pello, Senior Assistant General Counsel. This is agenda item H, which is discussion and possible action on readoption, revision, or repeal of 5 rule chapters that are a result of the 4-year rule review. Just as a little bit of background, the 5 chapters that are undergoing the review are 16 Texas Administrative Code chapters 59, 60, 70, 72, and 73. And in terms of a little bit of background on the rule review process, the Texas Administrative Procedure Act requires each state agency to review its rules every 4 years to determine if the reasons for initially adopting the rules continue to exist and whether the rules should be readopted, amended, or repealed. As part of this process, the department publishes a notice of intent to review in the Texas Register, notifying the public about the 4-year review, but no rule text or amendments are proposed or published in that notice. And during the review, the department is assessing whether the reasons for adopting or readopting the rules continue to exist. It's kind of taking a look, if we adopted these rules 4 years ago, do they continue to exist? And the things that we're looking at when we review each of the rule chapters is we're determining whether those rules are obsolete, whether the rules reflect current legal and policy considerations, and whether the rules reflect current department procedures. Like I said, we don't publish any proposed text. There's no amendments or repeals at that time. So if the department receives public comments that are suggesting amendments, or if the department, it's in its own review, determines the rules are still necessary, but amendments need to be made to the rules, the department will propose amendments in a future standard rulemaking, going through the standard rulemaking process with proposed changes published in the Texas Register and open for public comment. So for the current rule reviews that are in front of you today, we published a combined notice of intent to review, and that was published in the Texas Register on April 16th, 2021, and the comment period closed May 17th, 2021. The department received 40 public comments in response to that combined notice of intent to review. The commission has copies of the public comments and a summary of the comments for each of the rules chapters. Again, we don't get into make any changes based on those comments, but any public comments received regarding readoption or repeal were taken under consideration as part of this review. And then any public comments suggesting changes to the rules will be taken under consideration for a possible future rulemaking. And again, any amendments to the rules must be made through the standard rulemaking process with specific changes proposed for review and public comment. So for these 5 rule chapters, the department conducted that review and determined that the reasons for adopting and readopting the rules for these chapters continue to exist. They're essential in implementing the applicable statutes and are necessary for the operations and functions of the commission and the department and for the operations for each of the affected programs. So today we're asking the department's making a recommendation to the commission that you readopt all 5 rule chapters in their entirety in their current form, with a recommended effective date of July 15th, 2021. And I'm happy to answer any questions.
Thank you, Ms. Pello. Any questions for Ms. Pello? All right, I'll entertain a motion.
So move to adopt all rules in chapter stated by the general counsel 59, 60, 70, 72, and 73.
Is there a second?
I'll second it.
All in favor, say aye.
Aye.
Opposed? Okay, motion carries.
Thank you.
All right. We're going to go back to public comments, and I think, Tamla, are we ready for public comments?
Yes, sir. We have Mr. McBratney. He should be in the room. Mr.
Okay.
McBratney.
Okay, and I see Commissioner Collier, you just joined us. Is that accurate? I don't know if she's here or not. I just saw her pop up on my screen. Maybe
don't
not. Maybe it
see
was
her
delusion. Commissioner Collier? Okay. All right. So, I'm sorry. I apologize, Tim. Who's on the line right now?
Mr. McBratney.
Mr. McBradney. Okay, Mr. McBradney, can you hear me?
Yes, sir, I'm here. Okay.
Okay, good.
I'm
All right.
visible. I'm here, Mr. Chair.
Okay, thank you, Commissioner
Don't
Collier. I
know if video
appreciate it.
showing or not.
I'm not sure why.
I'm not sure. Took me a while to log on. Let me
That's okay. We're here in public comment. So if you can't hear, let us know. Mr. McBradney?
thank you so much.
All right. Can you hear me?
Yes, sir, I can hear you. Okay.
Now, I'm going to explain something to you. Please, thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Tamla will keep time. Please understand the commissioners are not allowed to ask questions or engage in a discussion with you about anything that is not specifically on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be the decision makers in that case. Do you understand, Mr. McBradney?
Yes, sir, I do.
Perfect. Okay, you have 3 minutes. Go ahead, sir.
Yes, sir. Ladies and gentlemen, thank you for having me here today. My name is Brendan McBratney. I am representing the state of Texas Massage NV clinics, and we're encroaching on kind of a new world. In the spirit of what we do, our entire existence is to help people. Our core values and our brand promise is to help people feel their best. The world is incredibly stressed out right now. There's a lot of people needing our help. And last year alone, primarily due to a lack of talent and people able to provide services, we turned away nearly 800,000 clients just at Massage NV clinics alone. And I'm speaking on behalf of not just us as a brand, but also the entire industry. There's 2,000 massage therapy establishments in the state of Texas, all in dire need of massage therapists. And I know in Tdlr's mission, y'all are here to protect people and students that are looking to attain licensure. You're here to protect the public and ensure that they have a safe and effective therapeutic experience. And our education system, as it's existed for the last several decades, has not been able to meet the demand. Our clinics alone in Texas, we could hire 777 massage therapists today, approximately. And that's 777 jobs today now, not including the jobs that'll be coming available as the whole entire industry grows and as we have turnover in the clinics. So hundreds of therapists every year need to be licensed and trained properly with quality, affordable, and convenient, accessible education. And just in this last year, in this last legislative session, the Senate Bill 1130 was passed, which provided a means for online education access. And we in the industry are trying to lead through because we need therapists badly. But right now, the existing school system does not provide quality education at a convenient and accessible and affordable price. The cost of an average education for massage therapy, it's a 500-hour course, can be completed in as little as 6 months if it's full-time or even in the evenings for a year, but it can cost upwards of $10,000. We're trying to explore options for a public and private partnership that can help reduce the cost. We have online accessibility. The quality of the education is extremely important. And just in the last fiscal year, since August, there's only been 288 licenses that have been issued so far in the entire state of Texas. And as I mentioned, we could hire 777 just in our locations alone. And what we're looking for from Tdlr is we would love to partner with you and partner with higher education. Higher education has never been involved in the massage therapy industry to this point. It's been a loose association of smaller one-off, some vocational for-profit schools, but a lot of small independent businesses that simply cannot meet the demand for the talent, nor has it been accessible, convenient, and affordable. I'm in Frisco, Texas, here in North Texas area, and I can tell you the closest school to my location is nearly 15 miles away down in Dallas. And it's just not convenient with people leading busy lives with children. The pandemic introduced online education as a potential. The quality of that education has been proven already to be excellent for the people that are coming out. Then the hands-on therapy can all be done in location. And the last piece of the puzzle that really comes into play is in the occupation code as we read it, when we bring higher education to the fray, section 455. Am I out of time?
Yes, sir.
Okay.
I'm gonna give you another 30 seconds to close because
Okay.
what you're saying is interesting. Go ahead.
Yes, sir. As we read the code, section 455.004 of the occupation code is the applicability of the chapter, which higher education doesn't seem to be a part of. It says that higher education or any educational institution approved by the state of Texas is not subject to that entire chapter. So we want to work with Tdlr to come up with a system that can help higher education meet the demand so that when a student is passed through the program with quality education, they can apply for licensure and be made available to become a licensed therapist in the state of Texas with a high-paying job.
Mr. Brady, I can tell you, thank you so much. Again, we're restricted and handcuffed a little bit on what we can. I know the commissioners, and I've worked with them. They are very passionate. Each commissioner you see is very passionate about what you just stated. There will be certainty of follow-up with you. So thank you for your time. Thank you for your input. It's your grassroots type knowledge that helps us do our job better. So we appreciate it.
Yes, sir. We're here to help in any way we can. We're looking forward to the entire industry. So thank you, ladies and gentlemen. Make it a wonderful day.
Thank you, Mr. Bradley. Okay, Tim. I think that's it. Again, I think we're going to jump into executive session. You guys have done an amazing job, so we're way ahead of schedule. What time is it now? 8:54. Mr. Where were we at? Mr. Bowen, how many minutes do we need for executive session, do you think? You're on mute, Mr.
Sure, this is Brad Bowman, General Counsel. I would say about 20 to 25 minutes.
Okay, so let's say at let's do 9:20. We'll reconvene here, and so we're gonna go to executive. Let me go read this to you. We'll now go into executive session to consult with our attorney under section 551.071 subsection 1 and 551.071 subsection 2 Government Code. The time is 8:55. After the executive session, we'll take a break and come back at 9:20 and pick up on any actions on the executive session items, and then begin the contested cases. All right, let me remind you, commissioners, let's just jump into executive session. I'll do a break afterwards so that we can do, yes, Commissioner Castaneda.
Can I get the invitation for the
Yes, ma'am.
executive session, please? Sent to me
Pamela's
again.
nodding, so yeah, absolutely.
Yeah,
And so,
I don't have that one either.
Neither do I.
Oh,
Commissioner Collier, do you have it? You're on mute, Commissioner Collier.
I'm good. Let's just rock and roll. Let's go. I'm good.
Chairman,
have
I
it.
resent the connection to everyone.
Okay,
Okay.
we'll
I see it.
if you have any problems, we'll get back on it, and then again, we'll come back here. So log off, and we'll see you in the executive session. Thank you. 9:37. I'm calling the meeting back to order. Item number J, there are no actions needed on the executive item session. So we'll move on to contested cases. All right. And so if anyone has indicated that they are appearing today for a case, staff has provided them with information on how to connect to this meeting, and we'll bring them into meeting when we announce the case. So we have the first case.
Yes,
Pam?
sir. Yes, sir. Kareem Aziz and Mr. Huntsberger is here for that case.
Okay. Mr. Aziz, Mr. Huntsberger, can you hear me? Mr. Aziz.
I'm sorry, the respondent's attorney, Mr. Huntsberger, is here.
Mr. Huntsberger, can you hear me? You're on mute, Mr. Huntsberger.
I can hear you.
Perfect. Good to have you. Okay, is Mr. Aziz here? No? Okay.
I'm sorry. Could you repeat that?
Is Mr. Aziz here? Is he present with you?
He is not present with me, no.
Okay. Well, I'm gonna read this to you, Mr. Huntsberger, and then we'll continue on. Okay. We'll hear from the prosecutor first, then then the respondent. You have an opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak. Tam will keep time. We'll do a possibility of a 3-minute rebuttal if needed. Please understand the commission can only consider information that is in the record when the case was heard at SOA. So if you limit your comments to those matters, we would appreciate that a lot. So whatever's in the SOA here, that'd be great. Okay?
Okay,
Okay. Do you understand, Ms. Huntsberg?
I understand.
Perfect. Okay. Mr. Reed, are you there?
I'm here. Can you hear me, sir?
Yes, sir, I can. Okay. We're going to start with you. You got 5 minutes. Go ahead, Mr. Reed.
Good morning, Mr. Chairman and Commissioners. My name is Anthony Reed, and I'm a prosecutor in the Enforcement Division. In this case, respondent failed to perform a tow in a safe and competent manner on 2 separate occasions, Class C violations. On another occasion, respondent performed a tow without a valid license, a Class B violation. The ALJ recommended a 1-year probated suspension with no monetary penalty for unsafe towing and a $2,000 penalty for unlicensed towing. The department contends the safety violations were particularly egregious. We request that you modify the PFD to impose a penalty of $4,000 for each instance of unsafe towing and $1,500 for unlicensed activity, totaling $9,500. The department revoked respondent's tow operator license by emergency order, leaving nothing to suspend. First, I'll discuss the emergency order, then the NOAV contested hearing. The emergency order originated when the Euless Police Department filed a complaint against respondent based on 17 police reports during 2 months of the summer of 2019. Particularly alarming was that 4 of the reports alleged towing with passengers still inside the vehicle. Recognizing the immediate threat to public health and safety, Executive Director Brian Francis issued an emergency order revoking respondent's tow license. An emergency SOA hearing was set to occur 10 days later, as required, to determine whether reasonable cause existed to issue the emergency order. The hearing was continued at respondent's request. ALJ finding of fact 4 said, quote, by moving for a continuance, respondent waived his right to an expedited hearing within 10 days of the order, unquote. Effectively, respondent rendered the license revocation final. Now, the NOAV hearing was held on May 28, 2020 to address program violations identified in the Euless police complaint and in a separate consumer complaint. The ALJ found the department proved 2 unsafe tow violations and 1 unlicensed activity violation. The unsafe tow violations. On July 1st, 2019,
19-year-old Maria Gonzalez sat in the back seat of an SUV waiting for her parents. The engine was running. Mr. Aziz lifted the SUV with his tow truck. Ms. Gonzalez opened her door and screamed at Mr. Aziz to drop the SUV so she could exit safely. Mr. Aziz instead insisted Ms. Gonzalez jump out of the elevated cab of the SUV. The second unsafe tow was more distressing. Ms. Salih, 3 months pregnant, was in a minivan with her 5-year-old and 7-year-old daughters. The engine was running. Mr. Aziz started to tow the minivan. Fortunately, a witness confronted Mr. Aziz, who dropped the minivan in the traffic aisle and drove away. Ms. Salih testified that 8 months after the incident, her daughters still don't sleep well, and that the youngest still won't get into a car without her mother present. Mr. Aziz admitted both incidents. His excuse was he didn't know passengers were in the vehicles. The ALJ said Mr. Aziz, quote, recklessly disregarded the known risk by not checking to make sure no one was in the two vehicles, which were running, before moving them, unquote. The violations were only about a month apart. Mr. Aziz should, at the very least, have learned the first time. The unlicensed activity, Mr. Aziz stipulated that on October 25th, 2019, he performed a consent tow without a license. The department requests the commission modify the PFD, 1, to assess a penalty of $9,500 for these egregious violations, and 2, to remove the probated license suspension since respondent's license has already been revoked. What questions do you have for me?
Any questions for Mr. Reed? Okay, thank you, Mr. Reed. Mr. Huntsberger, you've got 5 minutes. Go ahead.
Thank you. Good morning, Commission. First, I'd like to state that one of the things that is shown in the paperwork that Mr. Reed has submitted to the court is that these are the two violations he's talking about are categorized as first-time violations, that the proposed disposition on the case was a suspended, a probated suspension for 1 year. And it started, I think started like $500 fine, then it went up to $1,000, then $2,000. Now it sounds like they're wanting to double it again. This is a little bit of a witch hunt on Mr. Aziz. And the reason I say that is because one of the things that Mr. Reed has pointed out is that when Mr. Aziz, he's been fighting violations, and there were 15 alleged violations that the department had no evidence to support. These 15 other allegations were from the exact same safety enforcement officer. This is kind of like somebody who's driving around and the same officer stops them over and over and over again, giving them, say, speeding tickets. And there's no...
I object. Mr. Reed is bringing up things that were...
Tony.
Yes.
I mean, is he allowed to
Let's
object? I
let
thought I had
Mr.
my 5
Huntsberger
minutes.
continue unless this information was not brought up in the hearing.
So make it, Tony, Mr. Reed, just hang on, give me a second. Let Mr. Huntsberger finish. I'm sure I'll give you a chance to repeat it. Okay. Yeah. Go ahead, Mr. Huntsberger.
And I'm just responding to him saying that there were all these other violations. Yes, there were accusations of violations, but they weren't proven. They were not violations. They were, there was no evidence that these actually took place. Furthermore, the two instances that he is referring to, Mr. Aziz did testify that he did not know there were passengers in the vehicle, and as soon as he was alerted to that fact, he did stop. The original recommendations for Mr. Aziz was based on these first-time violations and was appropriate for the conduct involved, a probated suspension that by the time this actually came to court, he had already served the time period and his license would have been available for him to begin towing again. But because of the repeated and numerous attempts to increase the fine, increase the amount of the suspension, and eventually going to a revocation on a first-time offense, it is wholly unfair for them to be pushing such a harsh penalty on a first-time offense when the recommendation is a probated sentence, not even a suspension, but a probated suspension where he would have been able to continue to work. Now, nearly 2 years later, he's not been able to work. His license has been in a state of limbo where he's not able to use it because of the revocation and then the suspension here. And they're asking to revoke a license that has already been revoked for 2 years. He's not been able to work and impose a incredibly high fine, considering that the original recommendation was $500 for each of these fines. And it appears to me that they're trying to get some kind of punishment for 15 allegations that were not proven to be true, rather than looking at the facts of the original 2 violations that they do have here. We're asking that the court, this commission, follow the recommendations as they were originally were. A probated sentence for 12 months. I believe the original recommendation was $1,000 fine, and allow Mr. Aziz to reopen his business now after 2 years of being in this system and not being able to work because his license was revoked and suspended, and for something that should have never been suspended in the first place. It should have just been probated for 12 months and allowed him to show that he can operate his tow company in a safe manner now that he's learned his lesson from these violations.
Okay. Thank you, Ms. Huntsberger. Mr. Reed, just to give me a second here, I'm going to let the commissioners chime in. I know you had some opportunity for to contradict Ms. Huntsberger, but I want the commissioners to have a chance here. Go ahead, commissioners. Any questions?
Mr. Huntsberger, Dr. Callis, I have a question for you. So I just want to be clear that the 17 allegations you said the Tdlr only approved had evidence for 2. My question is, weren't these other 15 allegations by a police officer, number 1, and number 2, the 2 incidents that were shown? It sounds like when you read the evidence, it sounds like that these people were traumatized and their safety was at jeopardy big time whenever you hook up a tow truck to an occupied vehicle. So my question is to you, is that did he admit fault of that, or you're saying that he immediately stopped and cease and desisted to towing right after he found out people were in the vehicle? Because that's not what I read.
From what I understand, as far as the second violation, the one that Mr. Reed was talking about, the woman was pregnant, he basically lifted the vehicle, was informed that there was somebody in the vehicle, and that was it, that the vehicle never actually even moved. The first one, I believe he actually did move the vehicle, but then when he was informed there was somebody in there, he stopped.
Okay, because I know that she in court, or based on her testimony, said she had to jump 3 feet down to get out of the vehicle. And I'm just saying that those type of incidents are very unsafe for anyone. And I think that that is very problematic for me.
I'll add on top of that, from what I read, that both cars were running at the time. And I just can't imagine that a tow operator, and he said, well, I didn't know it was running. And I'm like, okay, hello. But that to me is a major add-on to this from an unsafe standpoint.
I think to address that, these tow trucks have automated hooking things. They don't even need to get out of the vehicle. They back into the spot behind the vehicle, and the little hooks come out and hook the tires. So if the car is illegally parked and he has a reason to tow it, he doesn't really even need to get out of the vehicle. And if he's hooking the back wheels, he may not have noticed that the vehicles were even running.
This is Commissioner Collier. If it was 2 o'clock in the morning, I could probably appreciate that. Everybody's, probably asleep. So my question for Mr. Reed, walk me through the timeline for the revocation that's already been in place so I can understand that.
We, in August of 2019, we got a complaint from the Euless Police Department. There were a list of 17 police reports, not all the same officer, and not all violations, but the police department indicated they arrested Mr. Aziz. It was later non-billed, but they indicated they arrested Mr. Aziz, and so we felt that there was a dangerous situation going on with people being towed. The second one that we went forward, we set an emergency hearing, which is required after the revocation order. The respondent got an attorney, and the attorney filed for a continuance. And there were several other continuances, and it wasn't until May that it was heard, and what was heard were the things that I thought were most serious and I could prove.
And I appreciate that, Mr. Reed. What was the actual date that the revocation took place?
August 29th, I believe.
Thank you.
And the hearing was set for September 10th.
Okay, thank you.
And that was 2019, just so there's no confusion as to, he just said August. It's August 2019 was the revocation, if I'm not mistaken.
I'm very clear on that. Thank you.
Thank you.
Excuse me, September 9th, I believe, was the hearing set.
Any other questions? Okay, commissioners?
I have a question for Mr. Bowman real quick.
Go ahead.
For clarification, the PFD, I kind of feel very strong that he has had revocation of his license for over a year, which was the emergency order recommended. The only thing that I'm questioning right now is the amount of fine that is recommended. I was under the impression after reading this that I thought that I would like to make a motion that we allow a $2,000 fine and the concession of law 13 through 15 and approve the PFD as written. What I'm trying to say is that in order for me to move forward, I'm making a recommendation that we accept the time frame and then just have that fine of $2,000. That's what I'd like to do.
And Mr. Chairman, Mr. Brad Bowman, the amount of the fine is within your discretion. So if that's the appropriate penalty and that's what the Alj recommended, that is within your discretion to offer. We would recommend along the lines of what you outlined, adding some conclusions of law that sort of tie up the emergency order, recognizing that there was a revocation, that the Alj did not directly address that in the PFD, but recognizing that that's what happened, and then so he can move forward with potentially regaining his license or applying for his license.
Mr. Chairman, that's the will that I'm trying to do, is that I believe that he has paid his time for revocation. but I definitely feel strongly that if he comes before us, and I will have less leniency, but I would still like to offer in my motion a $2,000 fine.
Okay, Dr. Callis, just let me give you one more arrow in your quiver that is available. That there's an opportunity to educate or re-educate the licensee in that same regard too. So you have the license, fines, and education opportunities to kind of to work in that. I see your concern. I'm not guiding you in any direction. I'm just making sure that all
You're not, sir. I didn't know that was something that I would like to do. I would also like to encourage education for Mr. Aziz in order to make sure that this type of unsafe manner is never done again. And I think if you allow us in my motion, I would like to have education. I'd like to have a $2,000 fine, and I'd like to have conclusion of law 1315 to be able to allow him to regain his license on those pretense.
This is Commissioner Collier. I second that if the language is acceptable, but I'm very much a proponent of the education piece.
Excellent, excellent. Okay, we got motion and second. Any further discussion? Okay, all those in favor of the motion, say aye.
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 Opposed? All right, motion carries. All right, Mr. Huntsberger, I guess the staff will get with you on the specifics of what you, on follow-up on the issue that we just talked about, but I think fairly straightforward, and I think, Brad, we got the motion properly, I'm assuming, or you would have spoken up, right? Correct?
Yes, I think we understand the motion, and we will prepare a written order to that follows along with that.
Excellent. Mr. Reed, thank you so much. Ms. Huntsberger, thank you so much for your time. Appreciate it. Both of you.
Thank you.
Okay. So case number 2 is Mr. Soriano. We're going to have a continuance on that, commissioners, for our August meeting. So we'll just put a bookmark on that one. We'll move on to case number 3, Ms. Bloom. Tamla, do we have Ms. Bloom on?
Yes, sir, Chairman. We do have Ms. Bloom and her attorney, Ms. Betty Smith. And Chairman, we had a technical breakdown in the lobby, so we have a call-in user, I believe.
Hello?
Ms. Dancy?
Yes.
Ms. Dancy, we're going to move you back to the lobby. We inappropriately moved
Thank
you at
you.
this time. Okay, we'll move you back to the lobby. And our
Okay.
other call-in user is Ms. Smith, who is the attorney for Ms. Bloom.
Okay. Ms. Smith, can you hear me?
Yes, I can. Can you hear me?
Yes, ma'am. This is Commissioner Figueroa. Ms. Bloom, are you on the line? Ms. Bloom?
Yes.
Okay, so Ms. Bloom, I want to make sure. Ms. Smith, is Ms. Bloom with you?
No, I'm currently on vacation, so I'm in
Okay.
rural northern Michigan.
Okay, Ms. Bloom, okay, Ms. Smith, you're both on there. Okay, I want to make sure and go through this. I'm gonna read these to you, and then we have Ms. Hurtado. You there, right? Where we at? Yes. Okay, Jessica. Yes. Okay, I'm gonna read this to you real quick, both you ladies, and then I'm gonna make sure that you got the guidelines for how we approach this. We'll hear from the prosecutor first, then we'll hear from you. You have an opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak, with possibly a 3-minute rebuttal. Please understand the commission can only consider the information that is in the record form when the case was heard at SOA. So it's got to be contained to SOA, please. So if you must limit your comments to those matters that were presented at the SOA hearing. Do you guys understand? Ladies?
We didn't get a hearing. Yes, sir.
Okay, okay, good. I don't have a picture of you guys, so I'm not sure who's speaking. So if y'all just, when you speak, make sure you state it's Ms. Smith or Ms. Bloom, either one, and go from there. Okay, we're gonna hear from the prosecutor first. Mr. Tata?
Good morning, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. I ask that you accept the PFD as written and revoke Miranda Bloom's massage therapist license as required by law. The ALJ decided this case without holding a hearing on the basis of the department's motion for summary disposition. Ms. Bloom was represented by counsel and her attorney filed a response to the department's motion on her behalf. After reviewing the arguments of both parties, the ALJ issued a PFD recommending revocation of respondent's license. In 1995, respondent pled no contest to and was placed on deferred adjudication for public lewdness. Then in 2014, the Department of State Health Services issued respondent a massage therapist license. The department took over that program in 2017, and we learned of the respondent's criminal history in September 2020. As a result, the department initiated the proceedings that resulted in the case coming before you today. This case involves the mandatory license revocation provisions in the massage statutes that have been considered in previous cases before the Commission. Those statutes state that an individual is ineligible to receive a license and that any license they hold must be revoked if they enter a no contest plea to or if they receive deferred adjudication for a sexual offense. The elements of public lewdness include knowingly engaging in an act of sexual intercourse or sexual conduct in a public place or in the presence of another who will be offended or alarmed by that conduct. The ALJ found that public lewdness is a sexual offense and concluded that the respondent's license should be revoked. Because the respondent pled no contest to and received deferred adjudication for a sexual offense, the law leaves you no discretion in this case. I ask that you continue to consistently apply the massage statutes in this case and adopt the PFD as written, and I'm available to answer any questions that you may have.
Any questions for Mr. Totto? Okay. I guess, Ms. Smith, are you going to speak on behalf of your client?
I'm going to let her do most of the talking and convey her experience to you. Real quick, just wanted to open with, I obviously can't speak to why the department did not discover my client's criminal history prior to 2020, as it was fully disclosed on her initial license application as directed, as instructed, and at the time of her initial licensure and subsequent renewals, she followed all of the rules and guidelines that were given to her. And at this point, I understand the law says what it says, but at this point, we feel like she was misled by the government agencies and is now suffering the consequences for going along with what she was asked to do. So Miranda, if you'd like to describe that, please.
Hello, my name is Miranda Bloom. I'd like to thank everyone for this opportunity to speak today. I've been a massage therapist for 7 years. There's never been a complaint about me. I love what I do. I don't understand how this is happening. This has been truly destructive to my life. This is a 25-year-old arrest. Happened to a child. I was 18 and poorly represented by a lawyer who worked for the club and not for me. And as Ms. Hurtado speaks about that I may have been someplace where people would be offended, I was a topless dancer in a topless bar. No one there was offended by my behavior.
I'm sorry to interrupt, but none of this was in the record.
Because we were not allowed to
Ms. Bloom,
have a day in court. So that is why there was no record.
Ms. Bloom, give me a second. It's Chairman Figueroa. Listen, I'm going to give you a lot of latitude here. But our counsel has advised us, and we have to stay within what's in the SOA hearing. Understand your first, and so we need to make sure. Again, we're going to put you on a clock here, but just stay within those facts if you don't mind. And again, it's not a position we
want to. I am.
Okay.
A lot of the stuff is in the actual records that we put forward, but we were not allowed to have our day in court.
Okay, continue.
Okay. I don't know what else to say. This isn't fair. I have not done anything wrong. I've never hidden this arrest from anyone. I've never been accused of being unethical or a lack of integrity in any way. It's been 25 years. There's nothing in this new statute that says that it should be applied retroactively, and I vehemently disagree with the TDLR's interpretation.
Okay. Ms. Bloom, I'm going to give the commissioner some opportunity to speak to you. So why don't you commissioners go ahead?
Ms. Bloom?
Yes.
Hey, this is Dr. Callis. Here's my quagmire that I'm in. I totally agree with what you're saying. I know that dancing in a topless club and all that stuff, but here's where we are. The law is the law is the law, and I wish that they would have changed the law, but we just got out of the 87th legislative session, and because of the law of where it's stated is that it's handicapped and handcuffed me, and I have to go along with the PFD. But I'm just telling you, do I think it's fair? I will go on record saying that I wish they would have changed the law, because I'm all about giving people second chances. And you know what? I don't even think this is termed a second chance. This is just based on the law in the state of Texas, and us as commission, we have to follow that law. And I hate to say it that way, but I'm being as blunt as I possibly can. But if I could change the law, I would. But I'm just telling you, Ms. Bloom, I'm sorry that you're going through this, but this is the law that we're dealing with.
I hear you, sir. But I would like you to consider other laws that are also on the books that prohibit the retroactive application of new laws. And there's not a word in this that says that it's retroactive. Not a word. There's no reason that this should be applied to me.
Okay, Ms. Bloom, we're trying to stay within the. I'm going to Director Francis, I think, wanted to have a minute. So let me give him a second here.
That is in the record. That was our entire case.
I know.
This is Ms. Smith here. It was in our response to the MSJ. I don't have it in front of me currently, but I believe that was on the record.
What?
I believe what Ms. Bloom is talking about is in the SOA record.
Okay. All right. Okay. You're good. Any other commissioners? Any other comments? Okay. Ms. Bloom, I cannot thank you enough for your time and.
May I say one more thing?
Sure. Go ahead.
So at one point we were told by Ms. Hurtado that my only the only thing I could really do was get a pardon, and I have received a letter from the parole committee granting me clemency. So I'm just now waiting for the for the governor to read my case and decide if he's going to give me mercy or not. And I would ask today that you all give me mercy. Like, this is ridiculous. Thank you.
Thank you, Ms. Bloom.
This is Ms. Smith. I just want to thank you, Dr. Callis, and thank you to the commissioners. And I understand the position that you're in, but we appreciate you taking the time to listen to us today. So thank you.
Thank you, Ms. Smith. Commissioners?
Make a motion to approve the PFD.
I'll second.
Been a motion to approve PFD in a second. All in favor, say aye.
Aye.
All opposed? Motion carries. Ms. Smith, Ms. Bloom, you have other courses that we can, and the staff will get with you. Cannot echo more of Dr. Callis's, and I know the other commissioners' feelings as well. But hopefully this can be solved in a way that we feel be justified. So thank you for your time. Okay.
Thank you. And if anyone has any connections to the governor's office, please reach out.
Thank you, Ms. Bloom. Oh, and Ms. Smith.
Thank you.
Thank you. We're going to go to the next case. Mr. Boyles. Tamla.
I'm sorry, Chairman. Yes, sir. Mr. Bowles is here and he is being joined to the meeting now.
Okay. Ms. Bowles, Mr. Bowles, you there?
I'm here.
Okay, how you doing, Mr. Bowles? Do you have any attorney or it's just you?
It's just me.
You're gonna have to speak up, Mr. Bowles. I can barely hear you.
It's just me.
Okay, I'm gonna read you some instructions and then we're gonna go from there. We'll hear from the prosecutor first, and then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak with up to possibly 3-minute rebuttal. Please understand the commission can only consider information that is in the record when the case was heard at the SOA hearing. So anything that was stated in the SOA hearing is what we got. So you must limit your comments to those matters that were present at the SOA hearing. Mr. Bowles, do you understand?
Makes sense.
Okay, good. Mr. Tata?
Thank you. Jessica Hurtado, Enforcement Division. I ask that you reject the PFD as amended by the ALJ and revoke Andre Bowles' Class A barber license. After the PFD was issued, I filed exceptions because I believe the ALJ did not properly consider all the evidence at the hearing. The ALJ subsequently amended her PFD to make additional findings of fact and conclusions of law, but did not change her recommendation. In 2013, Mr. Bowles was licensed as a Class A barber. Then on April 26, 2018, Dallas County Narcotics detectives executed a search warrant at the location of Respondent's barbershop. Inside the shop, officers found 2 bags containing approximately 13.5 grams of cocaine and a digital scale. More cocaine, as well as approximately 85.5 grams of marijuana, were found in the respondent's vehicle parked outside the shop. As a result, respondent was arrested, and in February 2019, he pled guilty to manufacture and delivery of a controlled substance, a first-degree felony. The court placed the respondent on 5 years deferred adjudication community supervision. Respondent was 41 years old at the time of the offense. Then, in November 2019, Mr. Bowles renewed his Class A barber license. When asked if he had been placed on deferred adjudication since his last license renewal, he answered no. Mr. Bowles testified at the hearing that he sold cocaine out of his barbershop. By his own admission, Mr. Bowles was partying at the time and began selling drugs to make rent on his shop. These are the exact circumstances which the guidelines contemplate. The respondent used his barbershop as a front to hide the illegal sale of cocaine behind a facade of a legitimate business. As for his false answer on the renewal application, respondent testified at the hearing that he was scared and embarrassed and hoped his offense would not show up. Respondent's hope was that the department would remain unaware of his criminal history. The ALJ noted that respondent had complied with the terms of his supervision, including attending substance abuse classes, and considered the letters of recommendation submitted by respondent. After considering all of these circumstances, the ALJ concluded that Mr. Bowles' license should not be revoked. However, I do not believe the ALJ properly considered the circumstances of the offense, primarily that it occurred within respondent's barbershop a little over 3 years ago. Additionally, the ALJ concluded that the respondent misunderstood the criminal history question and believed he did not have to answer yes because he was still on supervision. However, this conclusion disregards the respondent's own admission that he answered no in an attempt to conceal his offense from the department. Because respondent's offense is directly related to his occupation, because he has not yet established a sufficient record of good conduct, and because he falsified his renewal application, I ask that you reject the PFD as written and revoke Mr. Bowles' Class A barber license. I am available to answer any questions you may have.
Chairman, you're muted, sir.
Oh, thank you. Any questions for Mr. Todd? I apologize. I'm working through this. It's only the 1,000th meeting I've had online. Okay. Mr. Bowles, can you hear me?
Yes, sir.
Okay. You've got 5 minutes. Please contain everything to what was in the hearing if you don't mind. But go ahead. You're on.
Well, basically, it was 4 years of time. Everything I remember in the meeting, everything that's in the documentation is as stated. I'm not going to change my statements about anything that I said. And as far as the decision of the people who, said not to, I don't know the initials or whatever, to not revoke my license. I mean, I agree with them. When I made the mistake of, putting the wrong thing on the documentation, and they told me to send everything that they wanted the second time, I sent everything that I could, that I was supposed to send. Very, very forthcoming and truthful about my case, my history, everything that's happened, and everything that I've done to, provide them with information that I'm not in that same situation anymore. So, really, I'm just gonna let you guys look at the documentation and go from there. There's nothing really for me to fight except that it's not what that was anymore. Totally different situation. So.
Okay. Thank you, Mr. Bowles. Appreciate your commentary. Commissioners, questions?
This is Commissioner Collier. Miss Jessica, was that the only, if you can give me a recall, offense in the findings of fact? Just the one?
Yes, Commissioner.
Ms. Hurtado, speak up again. I couldn't hear you.
I'm sorry. Yes, this was his only criminal history.
Okay. Any other comments, commissioners? Questions?
Mr. Bowles, I have a question for you. Did you go to any drug education classes? Are you still enrolled in any type of education? Are you doing anything to make sure that you stay on the straight and narrow to make sure that you are an asset to the community?
Yes, sir. I've actually taken. I was required to take about 4 classes. I also had to take 2 for my driver's license, and I've completed all of those classes. As far as staying on the straight and narrow, I could have done this at home, but I wanted you guys to see my barbershop, the environment. I also stream online so that everything that we do here at the shop is seen. I'm very much in the public eye. I just, started taking up coaching for another AAU team for kids. And so the statement about being embarrassed and about what happened, yeah, I'm embarrassed right now, but that doesn't mean that I'm not gonna, continue to move forward and try to be positive in this new community that I'm in. So, I'm very much a very positive person. So yeah, every day.
Thank you, Mr. Bowles. Mr. Chairman, I have a motion I'd like to make.
Okay. Just again, before we make it, if you don't mind, Dr. Callis, let me give you the arrows in the quiver. I know Commissioner Castaneda has.
Go ahead. Sorry.
Accept the PFD, which is the non-revocation, change the PFDs to revoke the license. You could do a middle, which is maybe a probated sentence and congruent with his probation. There's 3 levels. Just want to make sure, because sometimes it gets a little convoluted. I'm gonna come back to you, Dr. Callis. Commissioner Castaneda, you said you had a comment before Dr. Callis' motion.
I actually have a question. Does he have proof that he's attended these classes and that he's on the straight and narrow? I think you said you've had to attend 4 different classes. Have you sent any of that to us?
What was that last year? I believe I sent the.
I can answer that. We did receive some certificates from classes that he completed.
Okay. Before the motion, is there any other questions or comments from the commissioners?
Mr. Bowles, I have one more for you because I just want to be very clear, let the commissioners hear. How much longer is your probation?
Okay, so that's a twofold question. I talked to my lawyer, It's supposed to be a 5-year probation, but all I have to do now is go take 2 more drug tests, and then I go before the judge. And as long as my drug tests are clear, I will get off probation early. But it is supposed to be a 5-year probation, which would be 3 more years.
Thank you, sir.
Mr. Chairman, Brian Francis. Commissioner Castaneda, I was looking at the findings of fact. Number 8 and 9 specifically address the question you had about completion of the 2 drug abuse or substance abuse classes, as well as his drug offender education program certificate of completion.
Thank you, Mr. Brian Francis. Okay, any other comments, questions? All right, I'll entertain a motion. Yes, sir, Dr. Callis.
Mr. Bowles, I just want to let you know that I truly believe in your heart that you're trying to do the right things. But I'm going to tell you right now, don't embarrass me, because I'm putting my 100% behind you. And I'm telling you that I don't like to do this, but I feel it in my heart that I have to do this, because I think you are definitely, you're not hiding behind anything. You're standing up for what you've done. More importantly, that you've also have come before us and you're sitting in your barbershop. You own a business. You've already messed up once, and you're blessed to still have that. So what I'm going to tell you, and Mr. Chairman, I'd really like for y'all to support this. I'd like to accept the PFD as written and not revoke his license and allow him to maintain his business and let him keep going on a narrow path. I deal with drug addicts. I deal with people like this all the time, and they can be rehabilitated. And Mr. Bowles, I'm putting all my faith in you. It's up to you to be rehabilitated and to move forward. But that is my motion, Mr. Chair.
I'll
Okay,
second
we have
that.
a motion to.
Excuse
Is that a
me,
second?
this is Della. Just also, there's a technical correction to make. Dr. Callis, in finding of fact number 1, include that with your motion.
Please, ma'am, so move.
Okay, we had a second from Commissioner Castaneda, is that right?
Second that.
Okay, we got a motion second. Any further discussion? All right, all those in favor of the motion say aye.
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 Any opposed? All right, motion carries. PFD is accepted. Mr. Bowles,
Sir.
Dr. Callis was pretty clear with you. He just stuck us all on that same line.
Yes,
We
sir.
as commissioners believe everybody has an opportunity, so take it, run with it, and the only time I want to see is a celebration of your business being successful and an equal part of our state. You understand, sir?
Yes.
Yep,
No,
Mr.
thank you.
Chairman.
Thank you.
Yeah, Mr. Chairman, this is Commissioner Collier, Mr. Bowles. I can truly say from visiting barbershops across the state, and then even some students that are in barber colleges now, and many have said that having their license has saved their life and has kept them out of trouble.
Yes.
Have saved their life and kept them out of trouble.
I
You're
agree.
in a key position. You're a leader now in the community. You got to stay forward with that, because if I'm on the commission and your face is back in front of me, it should be for a celebration, as Chairman Figueroa says.
Yes, ma'am.
Well said. Thank you. Have a great day, Mr. Bowles.
Thank
Mr. Tamla, we're ready for the next one. Mr. Harding, case
Get-
number 5.
Give me a hard 2 seconds, Mr. Chairman. Hard 2 seconds. Hold on.
Yes. While she's getting ready, Tam, are we ready for the setup for the next one?
Mr. Harding had some connection issues, so Mr. Bowman's going to speak.
Yep, Mr. Chairman, this is Brad Bowman. Our staff was in communication with Mr. Harding, and he's been trying to connect to the meeting this morning, but has apparently had technical difficulties and has not been able to do that. It would be within your discretion if you choose to do that to continue this to the next meeting. I think we made attempts to try to work with him and get him connected, and it just has not worked. So
We're gonna be more accommodating to a lot of these. So let's put that in the same category as case number 2. So let's just put this off to August. Is that fair, Mr. Bowman?
Thank
yes,
you,
sir.
Mr. Chairman.
That's your.
Okay, perfect. Okay. Sir? Commissioner Callier, where are you at? Where'd you go? I lost her. Are you there, Ms. Callier? Okay, I don't see. Can you, Commissioner Callier? Can I see you? There you are. Thank you. We just deferred case number 5 to the August meeting. Just FYI.
Okay, thank you. Yeah, thank you for that. Yeah, appreciate it.
No worries. Case number 6, Mr. Smith. Is Mr. Smith online, Tam?
Mr. Smith is not present. He did not indicate that he would be here today.
Okay, so let's just go hear from the prosecutor, Mr. Hurtado.
Thank you. Jessica Hurtado, Enforcement Division. I ask that you accept the PFD as written and revoke Joseph Smith's ACR technician license. In 2002, Mr. Smith was convicted of a misdemeanor assault, and in 2003, he was placed on a 12-month deferred adjudication for a second misdemeanor assault. Then, in 2005, Mr. Smith pled guilty to and was placed on deferred adjudication for injury to a child. According to the arrest affidavit, respondent removed the victim's pants in an attempt to have sex with her without her consent. As part of his community supervision, the court ordered that Mr. Smith submit to sex offender treatment and counseling. The respondent was discharged from his supervision for that offense in 2009. In 2011, respondent applied for a registered ACR technician license, and in 2012, he applied to upgrade that license. Because it appeared that Mr. Smith's criminal history was behind him, the department took a chance and granted him a license. Then in 2016, respondent began sexually assaulting his stepdaughter, who made an outcry to a counselor at her school. The victim reported to police officers that respondent sent her inappropriate text messages and had unwanted sexual intercourse with her on several occasions. Although the victim's exact age is unknown, the respondent ultimately pled guilty to injury to a child of 14 years or younger, a felony offense. On November 15, 2018, respondent received deferred adjudication and was placed on community supervision for 5 years. Respondent will remain on supervision until November 2023. At the time of the hearing, there was a pending motion to adjudicate because Mr. Smith was not in compliance with the terms of his supervision. In December 2018, respondent applied to renew his license and answered no to the criminal history question. We cannot know for sure what happened, but for whatever reason, Mr. Smith's license was renewed without his criminal history being reviewed by anyone in enforcement. Then, in January 2020, respondent again renewed his license. Enforcement learned of his troubling criminal history at that time and initiated the proceeding, which resulted in this case. At the hearing, Mr. Smith initially attempted to shift blame to the department for giving him a license in 2011 despite his past at that time. Then respondent shifted the blame to his victim, whom he said made the whole thing up. Mr. Smith testified that the incidents never occurred and that recently his stepdaughter, the victim, had recanted the allegations. Respondent argued that he did not realize he was admitting guilt when he agreed to the 5 years community supervision. He also testified that he works primarily in residential homes and that he has a, quote, personal rule that he never enters a home unless someone over the age of 18 is present, and that his employer is aware of this rule. The respondent testified that he notified his employer of his most recent deferred and that his employer was responsible for renewing his application in 2018. The ALJ found that allowing respondent to remain licensed would afford him opportunities to commit similar offenses in the future. The ALJ considered that the most recent offense occurred just over 5 years ago and that Mr. Smith was 33 years old at the time. The ALJ noted that while respondent has worked in the ACR field for 10 years, he did not provide any letters of recommendation from his employers, customers, or other individuals who could vouch for his character. Based on these factors, the ALJ concluded that respondent's deferred should be treated as a conviction for licensing purposes and further concluded that due to the serious nature of his most recent offense, the lack of character evidence, respondent has failed to show he is fit to hold a license despite his criminal history. The ALJ recommends that you revoke respondent's ACR technician license. I ask that you adopt the PFD as written, and I'm available to answer any questions. Thank you.
Questions, Mr. Hurtado?
I'm ready to make a motion, sir, whenever you're ready.
And I'll second that.
All right, go ahead, Dr. Wesson, Dr. Callis.
Accept the PFD, very clear.
Commissioner Collier seconds.
Motion. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you. All right. Miss Dancy, I guess is the next one, case number 7.
Call me again.
Candace,
Hello?
Miss Dan-
Yeah, what's going on? I'm getting kicked out. I'm getting kicked, and I don't understand.
Miss Dancy, this is Chairman Figueroa. How are you today?
Not so great because I keep getting kicked out of this portal or whatever it is, and I don't know why.
Okay, well, just hang on, stay with me here. I understand technology is a challenge, but I want to make sure you understand where you are. You're in a meeting, and the commissioners can hear you. Okay, so
Okay,
we're going to hear your case. I'm going to hang on a second, Miss
let's
Dancy.
go.
Just give me a second, Miss Dancy. I appreciate your
Yeah, I'm
excitement.
ready. I'm standing on my own 2 feet.
Okay, Ms. Dancy, just give me a second here. So you're going to have to stand by, and the prosecutor's going to go first. Okay, so I'm going to read some instructions to you. I want to make sure you understand the instructions, and then we're going to go from there. Then you'll have, once the prosecutor has stated their case, then you'll have your opportunity. Okay, Ms. Dancy? Okay.
Okay,
So,
let's go.
I'm going to read this to you real quick. So you'll hear from the prosecutor first, and then you'll be your turn. You'll have an opportunity to speak. Make sure you speak clearly, state your name and who you represent. It's important you state your name because we can't see you. Each side will have 5 minutes. You'll have 5 minutes to speak with a possibility of 3-minute rebuttal. Please understand the commission can only consider information that is in the record from the SOA hearing. You must limit your comments to those matters present at the SOA hearing, Ms. Dancy. Hang on. Please don't interrupt, Ms. Dancy. Okay?
No, I won't.
Okay, anything in the SOA hearing. So if you're not contained in that SOA hearing, I'm going to have to interrupt you, and I don't want to do that. But I want to make, because it's 5 minutes. So I want to make sure.
Can I say one thing? Can I say one thing? I didn't have a SOA hearing, so that's only. I didn't have a hearing.
Or it'll be in.
I didn't have a hearing.
I understand. Or it'll be in the documentations that you submitted. It's anything in the documentation. We want to stay in the lane. So I'm gonna hear from the prosecutor first, and then I'll connect you in. Okay.
Okay.
Thank you, Ms. Nancy. All right, Mr. Tito.
Thank you. Jessica Hurtado, Enforcement Division. I ask that you accept the PFD as written and revoke Bridget Dancy's massage therapist license as required by law. The ALJ decided this case without holding a hearing on the basis of the department's motion for summary disposition. Ms. Dancy was represented by counsel at that time, and her attorney filed a response to the department's motion on her behalf. After reviewing the arguments of both parties, the ALJ issued a PFD recommending revocation of respondent's license. Just like in Ms. Bloom's case you heard earlier today, this case involves the mandatory license revocation provisions in the massage statutes that have been considered in previous cases before the commission. Just like in those prior cases, the law leaves you no discretion in respondent's case. In 2004, Ms. Dancy was licensed as a massage therapist by the Department of State Health Services, and in 2017, responsibility for the massage therapy program was transferred to the department. In May 2020, the department became aware of respondent's criminal history, which makes her ineligible to hold a massage therapist license. In fact, respondent was never eligible for a license, and the law requires that you now revoke that license. I personally have great empathy for Ms. Dancy and the serious difficulty that she faces in losing a license she has held for over 15 years. Still, despite that empathy, the law requires that I pursue this case, and the law requires that you revoke Ms. Dancy's massage therapist license. I ask that you continue to consistently apply the massage law as you have done in the past and adopt the PFD as written. I'm available to answer any questions you have. Thank you.
Mr. Chairman, you're muted.
Oh, Mr. Chairman.
Mr. Chairman, you're muted.
Okay. Thank you. Mr. Tito, thank you so much. Ms. Dancy, please maintain your comments until you're recognized. Commissioners,
go ahead.
Okay, just stand by. Commissioners, any questions for Mr. Tito? Okay, Ms. Dancy, you have 5 minutes. Please, again, just maintain your comments to what was there in this case. Thank you so much.
Okay, I don't have the paperwork in front of me, but I would like to thank the Department of Health for giving me a chance to pursue massage therapy. I would like to thank the Department of Disability and Aging for certifying me as a certified nurse today, as I am today. In the affidavit, I was listed as a healthcare risk. I have a great, I took that as greater fear. I have sympathy and empathy for everyone, but I think that what y'all did was wrong. What y'all did was change the law and move the goalpost. You changed the law and moved the goalpost. I understand that, but I'm not a risk or healthcare risk to anyone. That is greatly offensive. It was a defamation of character, and you didn't need to use it because you had the law on your side. You had the law. You didn't have to call me a healthcare risk. That's the thing, the only thing I had a problem with. Empathy and sympathy, I will go on. Ask Bridget, Dancy, owner, Smooth Touch, real results. I have no dealings with this department, none whatsoever, and no, never will I ever, because the way y'all treat people. No one has empathy or sympathy for someone who takes somebody's license after this many years and I haven't did anything. I'm proud of myself. After 5 years, I passed the test. I'm proud of myself. I'm not going to let y'all take nothing away from me. I'm not going to let y'all, y'all can take away the license, but you can't take away my life. My livelihood is still going to prosper. I'm going to still prosper. I'm not going to let this set me back. I'm still working. I'm still working. Smooth Touch will still go on. I'm a private business. I'm a boss and I'm an owner. And my name is Bridget Dancy. Whatever y'all department has fixed up, I know the laws have changed, but I will be in the fight to change leadership in our system. So that's my rebuttal. That's my say so, because I don't have nothing else to say to you guys. Nobody has sympathy or empathy for somebody, and then when you tell them your hair is coming out, or when you tell them the mental anguish you're going through, they say that you're not going through anything. So your department, I don't know what's going on with this department, but y'all let a hairstylist open her business without proper protocol. Then she had an armed white militia in front of her business with AR guns. So
Ms.
this
Ms.
department,
Ms. Dancy, Ms.
okay,
Dancy,
then I'm
Ms.
going to
Dancy.
stop right now, and that's I'm going to shut up.
Okay. Ms. Dancy, thank you for your comments. We got to stay within, I understand your frustrations, but we got to stay within what you have.
Now
directed. Ms. Dancy,
you have a job. You're an employee.
Ms. Dancy, please, I don't want to have to mute you. I'm just giving you some opportunity here. I'm giving you a lot of latitude. I'm allow the commissioners to comment, ask your question.
I didn't have a hearing.
Ms.
I
Dancy,
didn't have a hearing.
I understand. Okay, so you have to give us a chance. So please talk when you're recognized, okay? This isn't a free form. This is a commissioners meeting, okay? So when we call on you, please respond, okay? Commissioners, do you have any comments?
This is Commissioner Collier. I appreciate Ms. Dancy, you voicing your concerns and frustrations. The charge and the challenge that my peers on the commission have is being held to the law, and that existing law and that existing law in place dictates how we move forward. Do we like it? No. Do I like it? No. That's how we have to move forward within the confines of the law.
Thank you, Commissioner Cameron.
Go ahead.
Thank you. Ms. Dancy, hang on, Ms. Dancy. I'll call on you in a second.
Yeah, because I got to get somewhere because I got too much noise going. Okay, because I'm outside. Let me go around the corner.
Commissioners, any other comment? Thank you, Commissioner, again for your comments. Any other comments, commissioners?
Ms. Dancy, hey, Ms. Dancy, this is Dr. Callis. I want to let you know that I want to change one of the statements you made because I don't think you really mean what you said. Is that this commission is definitely sympathetic and empathetic. Let me just be very clear about that. I cannot help that the state of Texas law has put us in the predicament we are in today. What I recommend to you, and I promise you, you will hear it from me, that I'm very, very serious about this. I take my job very seriously, just like you take your job very seriously. As a physician, I am definitely sympathetic and empathetic. And every commissioner on this call and staff is sympathizing and empathizing with people every day. So the only thing I want to say to you, ma'am, the only thing I want to say to you with all due respect is that I feel for you, and I think that this law needs to change, but we as a commission are not the legislative body of the state of Texas. We are the volunteers. And what I'm trying to tell you is that please do not walk out of this meeting thinking that we are not sympathizers and empathizers, because I'm empathizing and sympathizing with you right now. And I'm sorry what you're going through, but I am handcuffed and tied based on what my cards have been dealt. So I just want to let you know.
Thank you.
Okay, I'm a certified nurse's aide, and I continue to be one right at this moment.
Hang on, Ms. Dancy, just a second. We're going to give you time.
His energy was coming at me real forceful.
I know, Ms. Dancy. Just give me a second, Commissioner.
I mean, I read energy. That energy was. I understand what you're saying,
Ms.
but
Dancy,
the energy was wrong.
Ms. Dancy, I'm going to have to mute you if you don't give me a second here. Each commissioner is going to have an opportunity. I'll give you a chance to respond, but you cannot speak. This is not a free form. It's a commissioner's hearing. So I need to keep protocol. So just stand by, Ms. Dancy, stand by. Commissioners, any other commentary? Any other comments?
No, the doctor, his voice is very loud too.
Ms. Dancy, hang on. Just give me a second here. Commissioners, any other comments? Okay, I'm gonna give you about another minute, Ms. Dancy. I don't usually do this, but I understand your frustration. I want to give you another minute to respond to Commissioner Collier, Commissioner Callis comments. Okay, but I want to tell you something very clearly. This is not about anything other than what's in front of us right now. I understand your frustration.
The law.
Okay, so you got 1 minute if you want to respond.
Okay, I understand the law has changed, and I understand you guys have to implement it. I understand everything, but in that affidavit, I was called a healthcare risk. That's what I was offended by. Nothing else because y'all had the law on y'all side. I just didn't want to be slandered in something that was said that was untrue. That was untrue. I've been a certified nurse's aide since 2001, 19 years. And that's what I was saying. The language of me being a healthcare risk in the affidavit was not called for because the law was in y'all's hands. You didn't have to call me and slander me to say that you wanted your license. You had the law. You had the 25. Yeah, I'm just saying you had the law. I'm just all saying y'all had the law. That was my complaint. I was called a healthcare risk.
Okay, Ms. Jancy, I appreciate that. Just a quick question in response, Ms. Jancy. Thank you for your comments. Thank you for your heart. Just give us a second here. Brad, Della, either one, is there a possibility? I'm not making this motion. I'm giving the opportunity for these commissioners to make a technical correction to that comment about the healthcare risk. Brad?
This is Brad Bowman. I'm not quite sure offhand exactly what Ms. Dancy is referring to, and maybe if we give us a minute to find if there's something in the PFD in particular, a language there that is.
It was written by Kent Sharp.
Okay, Ms. Dancy, just give us a second. I'll give you. I know I can't see, so I can't see wave your hand. Brad,
okay.
Take a second. See if you can find that language. I'm not making the motion again, commissioners. I'm just making sure we have every arrow in our quiver available to us.
What I would say is, if you want to adopt your order, and assuming you adopt the PFD, and if there's any language that's objectionable, and you want to make a note of that, I mean, we could certainly do that in the order, or make a note of that. In the order, it would change the outcome or the findings or conclusions of the judge necessarily, but that's possible.
Okay, that's what I needed here. That's
Let
what I
me see
need.
if we can.
Brad, go ahead and keep looking, but I wanted the commissioners to be informed. Okay, commissioners, any other comments or questions for Mr. Tato or Ms. Dancy? Okay, I will entertain a motion.
Mr. Figueroa.
Just one.
Go ahead, Chairman. Go ahead, Commissioner Collier. Go ahead.
Thank you, Dr. Callis. Miss Dancy, you indicated that the name of your business is, what's the name of your business again?
Smooth Touch.
Smooth Touch. Thank you. Okay, and you're in operations now, correct?
Yes.
Okay. All right. Thank you. Go ahead, Dr. Callis. Thank you.
Chairman, I'd like to make a motion, and I would like to accept the PFD with one caveat. I do agree with Ms. Dancy. I don't like the term saying that she's a healthcare risk. I think that is totally going against her certified nurse assistant's license, because if she was a healthcare risk, she wouldn't hold a nurse assistant's license. So if that is able to be withdrawn or redacted, I would like to accept the PFD as written with that statement redacted.
And I'll second that.
Okay, we have a motion. We have a second. Any further discussion? Yes, go ahead, Dr. Francis.
Brian Francis speaking. Dr. Callis, can we morph your motion to say that statement or any similar statement of that nature? So just in case that language
Yes,
isn't
sir.
found precisely there.
Yes, sir. I'm trying to help Ms. Dancy because I think that she would not be considered a health risk, but based on the statute and the law, she cannot hold her massage therapy license.
This is Doug
Yes.
Jennings. This is Doug Jennings, Assistant General Counsel. I have reviewed the PFD, and there is no reference to healthcare risk in the PFD. I believe that Ms. Dancy may be objecting to something maybe in a pleading or in an oral argument, but most likely a pleading made by Prosecutor Ken Sharp. The PFD simply states that Ms. Dancy is permanently ineligible for licensure due to criminal history, and just recognizes that. So I just wanted to go ahead and clear that up for everyone. That no modification to the PFD is needed. Thank you.
Okay.
All right. Thank you.
Okay.
Thank you, Ms. Dancy. Okay, so hang on. Any other further discussion? We have a motion. We have a second. All right. All those in favor say aye.
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 All opposed? Okay. Motion carries. Ms. Dancy, can you hear me?
Yes.
Okay. I think it was clear, Dr. Callis and Commissioner Collier, and the commission empathizes with you. The motion carried with that stipulation. We understand your concern for that wording. We understand your frustration with the law. You're not alone, and we understand the challenges that are in front of us. And we appreciate you coming. We appreciate your commentary and your information. You're always welcome to come forward if you have any other comments to the commission. Okay.
This is the only thing I have to say. The things that I'm doing now in my business do not have any. I made sure what I'm doing now at Smooth Touch, Real Results, has nothing to do with license and regulations. Texas Department of License and Regulations. What I'm doing now in my business. That's what I'm letting you know.
Thank you, Ms. Nancy. Thank you for that information. Thank you for your patience, and thank you for your time. Have a great day, Ms. Nancy.
Thank you, and you have a great day. Bless all of y'all.
God bless
Thanks,
you
Ms.
too.
Dancy. Mr. Chairman Figueroa, still with if we could just do due diligence to double check the language, and let's just make sure we do due diligence across the board. And if it's something that's in a document that we didn't draft, let's just, if doable, to send a letter or something, some consideration to protect that, I would appreciate that. Thanks.
Thank you, Commissioner County. I completely agree, and I think staff understands the emphasis put on that.
Chairman, I had one more comment about that. I know we've talked about this. This seems to keep coming up and coming up and coming up. Statutorily, we are handicapped. I would like to have it on the agenda for us to discuss as a commission to see how we move forward on this, because I think that there is a lot of people that are caught in the crosshairs that should be licensed and are not being licensed based on the integrity of the law. So, I mean, I know we can't do anything for 2 years, but it's just something I would like for us to discuss and see if we can move this back to an appropriate setting.
To your request, Dr. Callis, we'll put that on the agenda, and we'll see if we can get legal counsel to see if there's any workarounds that we can in the interim. So I agree. Okay, moving on to case number 8. Ms. Mares or Mr. Mares and Mr. Tato. Mr. Mares, is he on, Tam?
Yes, sir. Mr. Mares is here.
Mr. Mares, can you hear me? Mr. Mares. I don't see him, Tam, so I see him. Mr. Mares, can you hear me? You're on mute, Mr. Mares. Mr. Mares.
Yes. Hello. I'm sorry about that.
That's okay. 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 I'm going to read you some instructions, and then I want you to make sure you understand it, and we're going to go from there, okay? We'll hear from the prosecutor first. Then you'll respond. You'll have opportunity to speak. Make sure you speak clearly, state your name and who you represent. Each side will have 5 minutes to speak with a possibility of 3-minute rebuttal. Please understand the commission can only consider information that is in the record from when the case was heard at the SOA hearing. So you must limit your comments to those matters that were presented at the SOA hearing. Do you understand, Mr. Mares?
Yes.
Perfect. Okay. Mr. Tato, where you at? There you are.
Thank you.
Mr. Tato, go ahead.
Thank you.
Do we still have a quorum, Mr. Chairman?
Yeah. Yeah.
Okay.
Yes.
Okay.
We have
Thank
four.
you.
Four. There's 4
Thank
of
you.
us. Did Dr. Wessons leave? I mean, Dr. Callis? Okay. Okay. He stepped away for a second. Okay. Go ahead, Ms. Hurtado.
Thank you. Jessica Hurtado, Enforcement Division. I ask that you adopt the PFD as written, deny Juan Angel Merez's Class A barber license application, and revoke that license. Mr. Merez has been licensed as a barber since 2013. In August 2017, Respondent was arrested and charged with delivery of a controlled substance, in this case, cocaine. In 2018, Mr. Merez pled guilty, was convicted, and placed on community supervision for 8 years. The respondent was 24 years old at the time of this offense. Then in July 2018, while still on probation for his original charge, respondent sold 2 THC cartridges to an undercover officer, resulting in a second delivery of a controlled substance charge. In May 2019, Mr. Merez again pled guilty, was convicted, and sentenced to 5 years community supervision. Additionally, the state filed a motion to revoke his probation in his original case. The court instead extended respondent's community supervision in his first case for an additional 2 years. All told, Mr. Merez will remain on community supervision for these offenses until 2028. Because a barbershop can serve as an effective cover for drug sales, Mr. Merez's offenses are directly related to the barber occupation. At the hearing, Mr. Merez testified that he was a heavy drug user at the time of his offenses. He testified that he has since completed an outpatient drug treatment program and has been complying with his supervision. Mr. Merez's explanation of the offense to the department is that he was selling drugs in order to fund his own addiction. Respondent has only been sober for approximately 2 years. While commending Mr. Merez's rehabilitation efforts to date, the ALJ ultimately concluded that not enough time has passed for the respondent to establish a record of good conduct. Thus, Mr. Merez has not established that he is fit for licensure at this time, and he does not presently possess the trustworthiness required for a license. The ALJ recommends that you deny respondent's renewal application and revoke his Class A barber license. I'm available to answer any questions you may have. Thank you.
Okay. Any comments? Questions? Okay. Mr. Mares, you there?
Yes, sir.
Okay, you have 5 minutes. Go ahead.
I really have nothing much to say other than this was when I was a high use in drugs, and I could not control myself, and I had turned to selling to support my own habit. I just right now just really just asking for another chance to continue my career in barbering I have been sober these past going on already on 2 years, and I just wish to keep progressing and with myself, and that is all.
Okay, Mr. Morris, thank you for your comments. Commissioners, any questions for Mr. Morris?
Mr. Morris, hey, this is Dr. Callis. Do you take random drug tests?
No, sir. As of right now, I am on a drug patch, and well, pretty much every day, all day, is a drug test for me.
You're on, what does that mean, sir?
I have a patch, like a Band-Aid that I keep on my skin all day, every day, and every 2 weeks I go and I get it exchanged out so they can send with the lab within the state, and they notify my probation officer.
Okay, so what you're saying is that you have a transdermal monitoring device on that they remove every 2 weeks, and then they sample that device to see if you have drugs coming from your sweat glands or your pores.
Yes, sir. Correct.
Thank you, sir.
Any other questions, commissioners? Okay. I'll entertain a motion.
This is hard for me because I think a chronic drug offender and a chronic drug abuser, definitely it's hard to rehabilitate. But it sounds like that he's been doing it for 2 years. So I mean, I don't have a motion. I'm trying to get it through my mind because we as a commission, like I said, we empathize and sympathize with people. Where I'm struggling right now is that if you revoke this gentleman's license, then you have him not to be successful and no drive to want him to be successful at all. But on the other hand, do you just allow this major drug offense and him testifying that he was a major drug abuser to be the basically the obstacle that we have to think about? So I know I'm being redundant and I'm being rhetorical, but I mean I really want to support his constant sobriety, but I'd like to listen to Mr. Francis or somebody else help me out on this.
So, Dr. Callis, I mean, it did note, and excuse me, Brian, Commissioner Callie, because it did note that he's completed his drug patch program, and that's one of the things I highlighted when I initially read this. So otherwise, I could have been easily leaning towards being in conjunction with that drug patch program, right? So, Brian?
This is Brian Francis speaking here. Dr. Callis and Commissioner Callier, I was just thinking the same thing. It sounds like he is still wearing the patch. And so a question that you may want to have for Mr. Mares is how long is he required to continue to wear that patch? And maybe that's something, Dr. Callis, if y'all looking at it as a possibility of probating his license in conjunction with that or something just to think about.
But page 7 indicates that Mr. Mares has also completed approximately 20 months of the drug patch program.
But I think that's the time
But
period.
is that part of his probation?
But it may continue beyond that time period.
Okay, got it.
It says it's over.
Mr. Mares, Mr. Francis is totally he's hitting where I'm feeling. How much longer are you on probation? Number one, and number two, is your probation inconsistent? Is it consistent with you being on the drug patch program as well, or can you stop the drug patch program before your probation ends? Those are my questions.
I have a remainder 8 more years out of 10 that I've done already. And I have another 6 more months of the drug patch before having it taken off. I was to complete it 30 months on the drug patch, and I've already completed 24, if I'm not mistaken.
Can I ask you a question? Would you be willing to extend that time?
Of the drug patch?
Yes.
I have no issue wearing the drug patch. My only issue would be having to make the payments for it. But other than that, having it on physically it's not a problem at all.
All right, so Mr. Mars, I'm asking you another thing. Would you rather keep the drug patch on and pay for it or not have your license?
I'd rather have the drug patch on and pay for it than to not have my license.
That's all I needed you to say, sir.
Thank you.
Thank you.
Okay, okay. So let me reset here a little bit. Commissioner, any of the commissioners want to have a conversation or questions? Okay. All right, then I'll entertain a motion.
Go ahead, Commissioner Collier. I see you're getting ready to pull the trigger. Go ahead.
All right, thank you. So I'd like to make a motion that, were you thinking of probating, suspending, or where he still is able to continue to work, and that that the drug patch stays on for for that time period that he's on probation, or for a reasonable time period, which could be the next time he would have to look to renew his license. So Brad, if you can, yeah, I see your 4 or 5 fingers. Thank you.
Hang on. So we got to be careful because the requirements we're putting on staff are something we have to be cognizant of. Go ahead, Brad.
This is Brad Bowman. So it sounds like this would be a probated suspension of his license, and the period of time would run concurrently with his criminal probation, which I believe is for a total of 8 years. So the remainder of that, and then you want to add a condition. We would have the standard terms and conditions if he comply with his probation, comply with laws and rules of the department. And then you want to add that you continue the drug patch. And how long did you, well, there's 2 questions. One is how long do you want to do that? And then the issue that Chairman raised about the feasibility of department staff being able to monitor that, and I'd have to defer to enforcement on that question. But if, in terms of your motion, how long are you envisioning the drug patch requirement continuing on past the 6 months?
Yeah. So, and I'm sorry, when was the point of his license to have been renewed? So I'm trying to align what those dates may be, and we don't have to figure it out here. So it would be at the point where the next renewal point would have been for his license.
So
Would something like that, Dr. Callis, suffice? Or you look at something longer than that? I'm sorry about that.
Incongruent with his license renewals, what you're looking for. You want this. You want the. I just want to get clarification. What you're asking is that the drug testing be continued and congruent with his renewal of a license. Is that what you're asking?
Right, that's what I'm looking at from a possible time frame there.
I like what Commissioner Collier said, but I will just tell you what I'm trying to do based on science and data is that the longer you maintain someone being tested, the better chance they have to be abstaining from drugs. I don't think it requires them 8 more years. I'm just saying that within the next 6 months, I would definitely keep him under probation until his next renewal. And me personally, if that's another year or 2, he'll be 3 to 4 years clean. There's many data and many studies that say if they've gone past 36 to 48 months, their chances of them being rehabilitated are very strong. That's all I'm saying. I'm not trying to make Mr. Morris break the bank for 8 years, but I definitely feel that the longer we can push this out to keep him clean, it's going to benefit him and our and his family and the future Texans that he takes care of.
Okay. With that doctor's advice, Commissioner Collier, I'm gonna let you go back to that motion. Make sure we understand what the motion you want to propose.
Yeah. So again, I like to see. I'm not sure when his next renewal date would be for his license. I'm a believer in. I was thinking of the 3 years, and thanks for sharing the data, Dr. Callis. Be it if it's another year, because then that would be 36 months. Time frame. So whatever point that would be to be concurrent with whenever his next or upcoming renewal would have been.
So Brad,
Any thoughts with that, Dr. Wesley? So, go ahead.
Oh, I mean, is this renewal, are we're doing a 2-year renewal now on these licenses, right?
Is that correct, Brad?
Jessica, do you have the data on when his license expires and how long it renews for?
Yes, just 1 second.
So
While
I think
she's doing
let me
that, oh,
get the spirit of what we're trying to do here while she looks it up. To Dr. Callis's point, we're trying to hit that 36-month threshold, basically, right, Dr. Callis? Okay, and I think that's in alignment with Commissioner Collier's effort to get that in sync with the license. So as close as we can to get to that is what we're looking for. Brad, go ahead.
and while Jessica's doing that, I wanted to just add, and neglected to say, as part of the motion, the commission is also, it sounds like you're objecting to conclusions of law 11, 13, and 14.
Yes.
And would need to modify those to.
Well, is
comply
11 and
with
14,
your
is that
order.
what you said?
11, 13, and 14.
Right, correct. Okay. Right. Jessica, do you have
So,
you have that information?
yes, the license expired of January of 2019. And then he applied for a renewal in May of 2019. So if his license is, if it's granted, I'm not sure I'm on all the details of when it will actually become active because it's expired now.
Well, I'll just tell you what I'd like to see, Commissioner Collier, if it's okay with you to amend your motion. I would like to say his next renewal cycle, 2 years, he will still be in the drug patch program. And then I think that would push him out to 48 to 50 weeks. I mean, 4 years, 4.5 years. I think then we will be doing him a great service as well.
Yep. Yeah, and that's one noted that whatever it would have been, if it would have been renewed, it would have been coming in during that time.
Yeah.
So I appreciate that.
So to state your motion, your objection to conclusions of law 11, 13, and 14, correct? Mr. Collier, which in parts amending it to have a mandatory drug patch in congruent with the 2-year renewal process. Is that accurate?
That's correct.
Okay.
I'll second that motion.
Okay, there's the motion. Brad, do we need to amend that in any way for technical or anything else to get that spirit?
I think that captures it.
Okay, so we got a motion, we got a second. Any further discussion? Okay, I'll take a vote. All those in favor say aye.
Aye.
All opposed? All right, motion carries. Mr. Mares? Did we
Yes, sir.
lose him? Okay, listen, staff will get with you what happened here to give you clarification. You've been given a heck of an opportunity. I would not dismiss that in any way, shape, or form. And to Dr. Callis and Commissioner Collier's efforts, we're extending to get you where you need to be. Don't let them down or this commission down. You understand, sir?
Yes, sir. I understand.
Okay, staff will get with you. Thank you.
Thank you.
Okay, case number 9, Mr. Blake and Trevor Thielen. Now, commissioners, can we go through this one case and I'll do a 5-minute break after this? Is that okay, or is everybody okay? Does anybody need a break? Raise your hand. If not, we'll do it right after this case. Okay, so we're gonna do this place. Mr. Thielen, you here?
I'm presenting for Trevor today.
I'm sorry, who's it? Jessica? Okay, Jessica. Okay, thank you, Jessica. And Mr. Blake, is he here?
No,
Ma'am?
sir. No, sir. He
Oh.
did not indicate that he would be here today.
Okay, all right, great. Okay, Ms. Hurtado, you should get paid overtime. Go ahead.
Thank you. Commissioners, Trevor Thielen handled this case at SOA, and since he is unavailable this week, I'm presenting it for him. My name is Jessica Hurtado with the Enforcement Division. We ask that you accept the ALJ's PFD, which recommends that you revoke William Blake's Incident Management Tow Operator license. Mr. Blake was granted a tow license in 2017, and he renewed it in 2018 and in 2019. Later in 2019, he was placed on deferred adjudication for felony criminal mischief, an offense that is directly related to the towing occupation because it is a crime against property. Mr. Blake pled guilty to prying open a gate control box and damaging the control box and the 2 gates which protected a gated apartment complex. According to the probable cause affidavit, Mr. Blake did this so that he could drive his tow truck into the apartment complex to repossess a vehicle he mistakenly believed was inside. The property owners reported that Mr. Blake caused over $4,000 in damage to the control box and gates. The court gave him a 3-year probation that he is not scheduled to complete until 2022. Mr. Blake testified that he was compliant with his probation, but provided no independent corroboration of this from his probation officer. 11 months into his probation, Mr. Blake renewed his license. When he came to the renewal application question that asked if he had been placed on deferred adjudication for any offense since his last renewal, he falsely answered no. In the PFD, the ALJ notes that Mr. Blake gave no explanation or excuse for his false answer. The ALJ acknowledged that Mr. Blake provided 5 glowing letters of recommendation and that this offense was his only criminal history. However, the ALJ ultimately determined that this evidence was outweighed by more compelling evidence that the license should be revoked for 3 reasons. First, because the crime itself, committed in the course of using a tow truck to repossess a vehicle, was a serious felony offense, was committed while he was clearly an adult, and was committed recently, only 3 years ago. Continuing to hold a tow license will continue to present him with opportunities to commit similar offenses. The ALJ concluded that Mr. Blake is unfit at this time to continue holding that license. Second, the ALJ recommended revocation because of the false answer about his criminal history that Mr. Blake gave on the renewal application. She noted that he had seen the question before and had been on probation for 11 months at the time he gave the false answer, and that it was reasonable to conclude that he gave the false answer knowingly and intentionally. Finally, the ALJ recommended revocation because he currently lacks the trustworthiness required to hold the license. She noted that Mr. Blake testified that he never damaged the control box and blamed that on another person that was with him that night. However, the ALJ concluded that Mr. Blake's denial was contradicted both by his guilty plea and by video evidence described in the probable cause affidavit and police report. In the sworn affidavit, police officers described video footage as clearly showing Mr. Blake, who is identifiable from his driver's license photo, prying on the gates and disassembling and damaging the entry motor box. His continued denial of facts, which were established by the police investigators, and his own guilty plea, along with the falsification of the renewal application, support the ALJ's conclusion that Respondent is not trustworthy enough to be trusted with a tow license right now. And a quick side note about the trustworthiness portion of the ALJ's recommendation. While the legislature has set September 1 as the end of TDLR's power to revoke based on a lack of trustworthiness, honesty, or integrity, that power still exists today. So it should not create an issue for you to utilize that power in this case. If you disagree, however, you could still base the revocation on the first 2 reasons the ALJ pointed to. The ALJ recommends that you revoke the license, and we recommend you accept the PFD as written. I'm available to answer any questions. Thank you.
Any questions? All right. I'll
No
entertain a motion.
questions. This is Commissioner
yes.
Collier.
Go ahead, Commissioner.
No, I'll
was-
make a motion to.
Yeah, I was going to make a motion
PFD
as well. So
as written.
I second that, Commissioner Collier.
We got a motion and a second. Any further discussion? All in favor, say aye.
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 All opposed? All right. Motion carries. Jessica, outstanding job. Thank you. Thank you for your efforts and thank you for what you covered.
Thank you.
All right,
Thank you all.
commissioners.
Have a nice day.
We're going on to item L. I'm going to give you a 5-minute break because we're doing great on time, but give everybody a 5-minute break. It's 11:16. We'll come back here at 11:21. So just turn your camera off and mute your thing. I'll see you in 5 minutes. 11:22, I'm gonna call the meeting back to order. Okay, we're on item L, motions for rehearing. Let me read this to you, Mr. Bruce. I know you've heard it many times, but the sound of my voice should be pleasant to you right now. We'll hear from General Counsel first, and you will have the opportunity to speak. Make sure you speak clearly and say your name and who you represent. This is a motion for rehearing, which means that there had already been a decision made in your case. We're not here today to re-argue the case. It's an opportunity for you to tell us how we made an error in entering the decision against you. You'll be limited to speaking about those issues that we raised in your motion for rehearing. So we're going to limit it to 5 minutes, okay? The Assistant General Counsel will keep time, and or Tam will keep time, I'm sorry. And then we'll maybe have a 3-minute rebuttal. You good with that, Mr. Bruce?
I'm fine with that.
Perfect. Okay, Mr. Jennings, you have the floor.
Thank you, Chairman Figueroa, Commissioners, and good morning, Mr. Bruce. I promised Mr. Bruce we would keep this snappy. He has a court date, and so I'll keep this as streamlined as possible. This matter resulted from an order in which the Commission assessed administrative penalties against the respondent in the amount of $5,000 and also revoked the respondent's vehicle storage facility license. These penalties and the revocation were in response to this Commission finding that the respondent's company engaged in a flipping scheme wherein customers were induced by way of dishonest conduct to transfer their vehicles to the respondent's body shop. And I'll just touch on the main points of the respondent's motion for rehearing. The first claim of error is that there was no evidentiary basis for the ALJ to find that the respondent's employee engaged in deception. And I will just give a rundown of the ALJ's findings on this point. We believe this point of error is without merit. The ALJ found that the body shop employee misrepresented the content and purpose of forms that he provided to a complainant, a vehicle owner, to sign. The employee stated that the vehicle owner's signature would simply give the body shop permission to start the estimate process and did not disclose that the form would grant the body shop a power of attorney and would allow the body shop to tear down or repair the vehicle. The body shop employee also had the vehicle owner sign and initial blank documents. So the complainant, the vehicle owner, would not have known the information or charges that were later filled in on the form. The ALJ also found that the business operations and physical structure of the VSF and body shop were calculated to confuse and deceive. There was little, if any, physical separation between the VSF and the body shop. The businesses shared the same waiting room, and the employee working with the vehicle owner did not identify himself as an employee of the body shop or attempt to direct her to VSF personnel at all. Additionally, one complainant was charged exorbitant fees for transferring the vehicle, even though no work was ultimately performed on that vehicle. We believe that this testimony and this evidence paints a picture of that the respondent engaged in deceptive conduct, and I would suggest that you find this point of error without merit. Secondly, the respondent alleges that Tdlr may not use acts by a body shop employee as the basis for sanctions against a VSF license holder. I would draw your attention again to the ALJ's finding that the physical layout and the operations and the business practices of the VSF and body shop were intended to confuse and deceive. There was no dispute that the respondent owns both the VSF and the body shop, and that the evidence showed that the operations of the VSF and the body shop were entwined. And therefore, we believe that the acts of the body shop employee may be imputed to the owner. And so lastly, the conclusion is that the ALJ erred in admitting certain evidence, including certain statements and expert witness testimony into evidence. Again, we would remind you that the ALJ is the arbiter of evidence, is the judge of evidence, and that finding, those findings about the admissibility of evidence should not be disturbed at this point. On a further appeal, potentially, a district court could look at that issue. So all in all, we believe that the motion for rehearing does not allege any error for which relief may be granted and is therefore without merit. We would recommend denying the motion. Thank you. I'm available for any questions.
Okay. Any questions for Mr. Jennings? Okay, Mr. Bruce, you got 5 minutes. Go ahead, sir.
I'll keep this short since we've already been on, heard this case once before. I think that there's a couple of things that are not in dispute. Is that the vehicle owner and her husband came in afterwards, had time to look at the documents, and most importantly, they signed the document provided by the Harris County Sheriff's Department that warned them exactly of everything that the department is claiming happened to them, and they acknowledged that. And if you look at, and I screen share but it's Exhibit 2 to my motion for rehearing.
Mr. Bruce, can you? Okay, there you go.
There it is. There it is. This is the violation is that my client, is not honest, trustworthy, or integrity because the vehicle owner didn't appreciate what she was signing. But this is a Harris County Sheriff's Department in big bold letters telling her exactly what she was doing and exactly what she was signing. She did not deny that she signed this. And so the standard is, we all act with dishonesty, lack of integrity, and aren't trustworthy. Well, this document here, which we had to provide, under local ordinance, was provided and explained to her exactly the situation. We just don't feel that there was enough evidence to find that my client acted without honesty and trustworthy, or that the vehicle owner didn't understand what she was doing. I'm not going to, the other points of error we've talked about before, but she admitted signing this, and she admitted reading it and making copies of it. So, I mean, I don't, even if you say that, the whole purpose of this document is so that we don't have a he said, she said, what was told to the vehicle owner. That's why the Sheriff's Department put this out. So if you forget all the testimony, she was explained exactly what was happening. So we just don't think the evidence supported a finding of lack of trustworthy, integrityness, or honesty. I'm going to stop sharing it unless anybody needs it.
We're good. Anybody else need it?
No, I have it.
Thank you, Mr. Bruce.
No, I got a copy.
So if you believe everything else the department said, which we do dispute some of it, I think the evidence showed, supports everything, but there was a bunch of he said, she said testimony here. This document here shows that my client didn't act with a lack of honesty. And the vehicle owner knew, was given notice. I don't know what more we can do as body shop owners to give people notices of what they're signing, then providing them a document provided by the Harris County Sheriff's Department. It says it's from the Sheriff's Department. I'm going to leave it at that.
Thank you, Mr. Bruce. Thank you, Commissioner. Yes, Dr. Wessons.
Mr. Bruce, Commissioner Wesson, I noticed you wanted to share Exhibit 2 with us. You didn't share Exhibit 1 that we have on file. That they basically they gave those people a blank invoice. It says here, yes, on Exhibit 2 that you could do this. You're responsible for this, this, and that. But when the customer was given Exhibit 1, which is a complete blank, they had absolutely no idea on what the charges were going to be. So,
if I may respond, there was evidence offered at trial, and it was undisputed that all the prices were posted behind the body shop employee. There was evidence that that's pretty standard in the industry until the car is looked at, that the invoice, the estimate is not filled out. But I offered that is that she did not just sign one document, that she initialed it in 4 different places and signed it. She does not deny doing any of that. She does not deny that she was there sitting in the day after the accident with her husband at the body shop. So where is the dishonesty on my client's part? Yes, sir.
Yes, Dr. Callis.
Mr. Bruce, I love whenever you come and talk to us. I feel like you're part of the family. But I had two thoughts. One, this Harris County Sheriff's Office letter is the most poorly written letter I've ever read, and it's the most misspelled, grammatically incorrect letter I've ever seen in my life.
I can't do anything about that.
But here's where I'm confused. And me having an MD, a master's, a bachelor's, I'm just telling you, when you read right here, you are not required to sign any other document to release your vehicle other than an authorization from Tdlr. However, if you would like to have your vehicle moved from the storage lot to their body shop for repairs, you must sign a release and work order. Here's where I'm confused. the release and work order, or what if this thing that we call Exhibit 1, I think that's deceptive. There's nothing on there.
And again, going back, that is the standard until they get the vehicle in the body shop, because they can't touch it once at the DSF. You can't look at it, you can't touch it.
You don't agree with me that this letter is kind of confusing?
I understand it's kind of confusing. I'm not going to, it's not. And it's probably poorly written, and if the sheriff's department was.
And I didn't know, and also I didn't know we can dode anything. We might do, but we can't dode.
Yeah. And if the sheriff's department would hired me to write their letter, I could have written a very good letter.
Yes, sir.
Here today. However, that being said, they can't write the estimate until they get the car out of the VSF. So that's the whole purpose. So you got to have and they can't touch the car until they get a work order signed. And typically what happens is the insurance adjuster shows up and writes the estimate, and then they write on the work order fixed per insurance estimate.
Thank you, sir. I appreciate your comments, as always.
Yeah, and now that's a little outside the record. I'm not going to say it's not, but you asked a question, so I want to answer it.
Any other questions? Mr. Bruce, I got to jump in here just because I very rarely do. But I got to tell you that the signature, it states, I hereby authorize the above repair work to be done along with necessary material and hereby grant. So they are signing a blank check, just for the record. I mean, so that's a document that your client does control, unlike the sheriff's document. So there may be an interim document you may advise your client that can be that bridge between, I can't give you estimates until I look at it, but I want to touch your vehicle, but not charge you for something that I'm just signing a blank check. Just my 2 cents.
I understand, and I'm not saying that the documentation and all this is just personal current, but the question is, did they try to intentionally hide something that they weren't going to start working on this vehicle? You know, and they didn't, you know, I mean, whether the documentation is badly written, you know, there was, you know, these people had time. She's there with her husband. She was a perfectly competent individual. You know, you are kind of charged with reading some of the documents you sign. And so, and then you're given something from the sheriff's department to say, hey, you know, take a second look, because, you know, although badly written, but, you know, that's, you know, there was just no deception, I mean, on our part.
Mr. Bruce, I got one more comment for you, because you know what just popped in my head, and I think you're going to laugh at this. This is what the legislature just hammered physicians about: out-of-network balanced billing. This reminds me of it, where you get treated, and all of a sudden you end up with $100,000 bill. That's all I'm saying. Is that
I got you. And you know, over the years, I have, you know, tried to fix things in the industry, especially here locally, with some success or some not. But I understand this is a problem. I just don't think you can say, gee, we could have done it, but doing it better does not mean we showed a lack of honesty and trustworthiness and integrity. This is the first violation for this company on this issue. And so I just don't think it met the legal standard. We talked about this document before, but I wanted to bring it to the commission's attention in their motion for rehearing.
Okay.
I think part of the issue is the joint location. You know, it's like, you know, did the person put on a hat for the VSF, and then did he take that off and put a hat on for the body shop, and then just point to a sign there and say, hey, this is what you're going to do. You know, I mean, it's all convoluted in that regard. And that's where I think some of the dishonesty deal, it wasn't spelled out, is what I'm thinking.
But I will, and this is on the record because I made this argument. When you go in to buy a car, right, you're told a bunch of things, and some, you know, and there is puffing in the sales pitch. So, I mean, did the salespeople pitch, you know, puff some? Yes, they do. But does that rise to the level of dishonesty? It really doesn't, you know, because you have this documentation. I mean, and there was testimony that the price of everything was very clear right behind where they sat.
Well, I know, but if you want to do that with a car deal, by the time you get to the point where you're signing the contracts, it's all spelled out and all the numbers are there.
Yeah,
you know,
well,
in this case, they're not. So,
and there was, and the testimony, and there was no conflicting testimony, was that they understood that the car was not going to get fixed. It was just being pulled out of the VSF to get a better price on the total from the insurance company. There was no, and there was, the vehicle owner testified that they did understand that.
And that's
Okay,
great.
let me,
I better
only
stop.
only because it's you, Mr. Bruce, I'll let this go a little bit, but let me
I understand.
let me go back to make sure that this is about the opportunity for us to tell how we erred in that decision against you. So, commissioners, I want to reset this motion for rehearing. We don't want to adjudicate this. I can see Brad's eyeballs coming at me from the screen. So let's just stay on task here. So, any other comments about that? Any errors? Yes, sir.
This is,
Well, hang on,
if I may, before Mr. Jennings speaks, this is Commissioner Collier. So was this exhibit from, I guess, at the then Sheriff Adrian Garcia's office, was this presented during the hearing? Is that what this says?
Yes, it was. It's part of the record. Both Exhibit 1 and Exhibit 2 attached to the motion for rehearing are part of the record. And I think I referenced that in a footnote in the motion for rehearing.
Mr. Jennings.
Yes, thank you, Chairman Figueroa. Just wanted to take the opportunity for a quick rebuttal. There's no, we don't contest the fact that the ALJ considered both Exhibits 1 and 2, but we also believe the ALJ had the opportunity to consider not only forms signed, but also testimony from the complainants, testimony about the practices of the business, testimony from the business's owners and general manager who approved of these business practices and found nothing wrong with them. The ALJ took the totality of the evidence into finding and that the respondent engaged in, and I quote, a calculated flipping scheme. So let's not narrow this down to one form or one sign. Again, it's a question about what the evidence in total exhibited. Thank you.
Okay. All right. Any other comments or questions? Yes, Commissioner Castaneda. Do you have one, or are you just waving at the screen? You're on mute, Commissioner Castaneda. You're still on mute. Yeah, you're on mute. We see you on mute, Commissioner Castaneda. There you go.
If the verbiage is written so wrong, it's deceitful. Why or who should rewrite the whole form? Who is that? The state? Is that us? Is that?
If I may respond, that verbiage comes from the Harris County Sheriff's Department. We're required by local ordinance to hand that form.
The city attorneys, whom? I mean, because it definitely works toward the advantage of the towing company and the people who are going to fix the vehicle. It just seems that it needs to be clear.
Yeah.
And especially if you're in an accident, they're traumatized a bit. And so who knows what they know, what they're signing.
Well, just to be clear, this was not signed at the accident scene. This was, the vehicle had already been in storage a day. They came in after, the day after the accident to the body shop. And that language was written by the tow truck division of the Harris County Sheriff's Department. I have spoken to them about that. I have no control over that. They just give us that form and say, you have to have everybody sign this. But it has to be signed at the VSF or at the body shop, not at the scene of the accident.
Okay. Any other comments? Okay. Entertain a motion.
I'll make my motion to deny the request for a rehearing.
Is there a second?
Second.
Okay. All in favor, say aye.
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 Opposed? All right, motion carries. Mr. Bruce, thank you for your time and your energy and effort and awakening us to some forms that we probably need to talk about later on.
Thank you, Mr. Jennings, for keeping it short so I can race off to district court now. And good seeing everybody. And although I never seem to win any of these, my parents very much appreciate seeing me on the web. It makes them feel like that law school education they paid for actually went to some use. But
Mr. Bruce, before you leave, I'm going to tell you I'm very impressed with your camaraderie, but more importantly, the way that you argue, you're damn good.
Thank you, sir. Thank you, sir. My mother's listening and she will appreciate that. I can assure you. Thank you, everybody. All right. Good to see everybody.
Bruce, work that out in therapy. Thank you very much.
Bye-bye.
Take care.
Bye-bye.
All right. Good thing it's not Mother's Day. We would have had a celebration on that one. All right. Item number F, or not, I'm sorry, not M. Item number M, staff reports, I think is the next up to bid. It is 11:42. So, Mr. Francis, you have the floor.
Mr. Chairman, Commissioners, Brian Francis, Executive Director with Tdlr. The first thing I'm going to report on is everyone's aware that July 8th will be a special session called by the governor. At this point in time, the agenda or the call items have not been set. There's some discussion about what's going to be on there. We anticipate that we will not be pulled into this discussion, but that crack legislative team that the chairman acknowledged early on will be on top of it. So we will let you know if anything changes in regard to the call. I'm now turning over to Christina Kaiser.
Good morning, Mr. Chairman, Commissioners. I'm Christina Kaiser, Deputy Executive Director for Regulatory Services. So the legislature did meet in regular session, as you know, from January through June 1st. And we had a lot of business in front of the legislature this session. We approached the legislative session with two big priorities in mind, that a budget get passed and that our sunset bill get passed. Thankfully, both of those pieces of legislation got passed, and they were in a form that we were very happy with. A highlight in the budget, we obtained an exceptional item requesting funding for phase 2 of our TLS project, the Texas licensing system. So we're very excited to keep moving forward on that. And also, of course, our sunset bill passed, which continues TDLR in existence for 12 more years and makes a couple of big important changes. During the session, we were monitoring in the neighborhood of 300 bills, and around 50 of those passed. And so now we are getting started on bill implementation. Brian has created 18 teams made up of various staff for bill implementation. Out of those 18, 9 teams are responsible for various parts of the sunset bill. So that is a huge part of our lift during this bill implementation cycle. The implementation teams will work on rule changes, changes to procedures and policies and forms that are needed. They will ensure that these important changes are communicated to the regulated industries through the advisory boards and through regular announcements from our OSC staff. And so everybody's busy at work right now. And that concludes my report. I'm happy to answer any questions. And if there are none, I'll yield the floor to Ms. Brandy.
Thank you, Christina. I appreciate the update. This is Commissioner Callier. 18 teams.
Yes, ma'am.
Right. That's good. My question is are those unique staff members on the teams, or is there overlap? Meaning, is it,
there are some staff members are on more than one team, if that's what you're asking. And there are core team members. And then there are people like executive consultants, for example. I'm an executive consultant on a couple of teams. And then on another team, I'm actually the leader of the team. There are also director consultants and certain other resource type appointees.
Okay.
Commissioner Kaiser, this is Brian Francis. When we did our kickoff meeting for the bill implementation teams, we had over 111 of our employees that were involved in it. As core members, consultants. You know our style. We want to get those folks that know the information intimately to help us craft the responses, and of course work collaboratively with the advisory boards and the industry to make sure that the products that we bring to the commission, but ultimately what we roll out, is something that makes sense and it's effective and it's minimal in its impact in terms of effort. We want to make sure that we take care of all the work on our end. So
sure,
there's a lot of folks involved.
Sure. No, thank you for that. I definitely love the approach. I appreciate that.
Thank you.
Okay, any other questions? All right, Mr. Francis.
Good morning, Mr. Chairman and Commissioner members. I'm Brandy Corrales. I'm the Chief Financial Officer for the agency, and just wanted to give a quick update on our hub activities. As you can tell from the report, we continue to be active in our hub program since we last met. We have attended 3 events already. And of course, we've already got some more coming up. Just to kind of give you an idea, the report that you're looking at only is giving you information for this fiscal year. However, just to let you know, we already actually have 4 events scheduled coming up in the next fiscal year, in fiscal year 22.
Hey, Brandy, this is Commissioner Collier. Forgive me for cutting you off. I did not get the reports in my FedEx box, so if you could screen share.
Most definitely. Let me pull that up right quick. Okay, are you able to see that, Commissioner Collier?
Yes.
Okay, fantastic. So you'll see that since we last met, we have attended 3 events. And we are continuing the schedule. Like I mentioned, we have 4 already scheduled in the next fiscal year, which we can start including on the upcoming events in this report. The other thing I want to let you know is that the semi-annual Consolidated Hub report has been published, and that information is located in the first quadrant of the report you're looking at. So for our agency right now, we are at 34.4% in hub spend. And then you can see that the state of Texas is at 8.34%. So we continue to solicit hub vendors and try to do what we can in that aspect everywhere that we have the opportunity. So that's all I have to report. I'm going to hand this off to David Gonzalez unless there are any questions.
All right.
Gonzalez?
I can still say good morning, Chairman Figueroa and commission members. David Gonzalez, Deputy Executive Director of Licensing Services. I'm here to update you on our SWAT efforts and progress on our licensing backlog. So our agency staff and consequently our operations have been negatively affected by the pandemic. There have been significant delays in issuing licenses, and for some of our programs applicants, they've waited months. It has even necessitated interventions by you, the commission, and our executive director with emergency license extensions, which is in effect until September of this year. I want to bring to your attention that Licensing Division Director Dee McEachern and her staff have led an all-hands-on-deck approach to addressing our continuing workload challenges. They recruited assistants from across the agency, even people that have never done licensing before, to help with our backlog. We're quite proud of all the Tdlr staff who stepped up to help with this initiative, which we've referred to as the Strategic Workforce Allocation Team. In addition to cross-training our licensing division staff on multiple programs and multiple databases, we have had staff from field inspections, regulatory program management, enforcement, education and examination, advisory board support, anti-trafficking unit, and a few others, all contributing to addressing the licensing workload. Needless to say, their focused efforts have shown much progress and perhaps even more importantly, promise for the future should, God forbid, we ever need to re-enlist their efforts for another pandemic. I'm proud to report that for the 3rd quarter of fiscal 2021, undoubtedly due to the help of the SWAT participants, our agency has issued 15,000 more licenses this 3rd quarter than any previous quarter prior to COVID. We just want to recognize the team's efforts to date and assure the commission that we know we still have some work to do. As you might imagine, as we go through the workloads, we've identified some room for improvement and aspects that could be addressed by fixing some of the technical debt we have. Consequently, in addition to the continued review of our licensing protocols, I assure you that we will be doing all that we can to incorporate any improvements and lessons learned during COVID into our new Texas licensing system, which may be able to solve a lot of our issues and challenges. And that's all I had to share, and I will turn it back over to Mr. Francis unless there's any questions.
David and team, thank y'all very much. Commissioners, look forward to seeing you in August at the next meeting, and we'll provide you an update on the impact of the rescission of the open meetings provisions that were put in place for the pandemic. Thank y'all very much. Time.
Mr.
All right.
Chairman, Before you adjourn, can I ask Mr. Bowman a question, since we're all on this together? Me and Commissioner Callier have a meeting on Friday for midwifery. Is there any way we can make that meeting early? That's Friday at 4 p.m. And I mean, I really don't want to have to be working. I mean, since I have a long week, I don't want to be dealing, I mean, I know I'm sounding a little whiny, but I mean, I really don't want to start my weekend at 5, 6, 7 o'clock at night.
Yeah, Dr. Callis, let us work on that and see if we can reschedule it and just want it kind of earlier in the day.
Please. If that's okay with Commissioner Callier. I mean, if she's okay with that.
Yeah, let me look. We'll talk about it offline. I look at my calendar. Thank you so much for making a comment.
And we'll coordinate with all the parties and see if we can work.
All right. Anything else, Dr. Callis? You want us to get your laundry for you? Dry clean? Anything like that?
I want you to come bring me a pillow so I can go to sleep.
Oh, good Lord. All right. We got to listen to the sound of my voice, Dr. Callis. I'll put you to sleep right away. All right, guys.
Mr. Chairman, just two seconds. I mean, folks can hop off if need be. Hey, Brian, I'm not sure for the upcoming towing advisory board. Since there were so many comments about the exhibit that Mr. Bruce talked about for this Harris County, document here, if there's any recommendations for improvements and so forth, I mean, this is just a phone call or two for me to present it to the folks at the sheriff's office over there. I just need to have some suggestions to say, hey, here's what's going on, here's how it can help. So if there's any language improvements we can suggest, I can kind of facilitate that.
Mr. Callier, we'll definitely touch bases with Christina's team and RPM, Todd Forster, who's our towing and vehicle storage facility guru.
Sure.
He's probably got some great relationships already with the Harris County folks. So
yeah.
we'll
Let's just see where we can make the improvements where we can to kind of help out. So thank you. Appreciate the full team and effort today. Thanks,
Absolutely.
Mr. Chairman.
Hey, so a couple things. One, it's going to be added to the agenda. We're going to be talking about this massage therapist issue. We're not going to let this go. So just stand by on that. That'll be on the agenda. We'll talk about these forms, if this highlighted for us. So if there's anything, I can't stress this enough. And I mean, something on the agenda you'd like to talk about, please forward it to me and Mr. Bowman, and we'll add it to the list. So you're not handcuffed in any regards. We just need that notice so that the public knows. So a lot of great issues come through here. And if we want to dialogue about it, I'm more than willing to host that conversation openly. Okay. August 9th is the next meeting. Is that correct, Tam? 10th?
August 10th.
Oh, Lord, you scared me, Mr. Chair. I was like, 9th, we got problems.
No, don't worry about it. Don't worry about it. Don't lose any more hair, Dr. Weston, or Callis. Don't lose any more hair. So you too, Dr. Weston. All right, I'll take a motion to adjourn.
So move.
Second.
Second, Commissioner Callier.
All in favor, say aye.
Aye.
Opposed? Excellent. Motion carries. Meeting's adjourned.
Great seeing you, commissioners.
Nice seeing y'all.
Thanks, I appreciate it.